Yes. Yes. Unless they get instruction, what is the use of taking another particular page? Ready? Yes. One. Yeah, I remember. Case. Who is mentioning why? Next. 152. Yes. Next page. Yes, ma'am. Steve. Yes. Where is yours? Who was this? It's for page 13.
construction is post the date of undertaking. This is walking on thin ice. Kindly come to the next paragraph. Next one. The said contention of the petitioner is contrary to the record. And also the order dated 20.710. In the writ petition, there is no mention about the fact, and even while giving, there is no mention that the petitioner had completed the aforesaid construction. So the ground is that my undertaking did not contain details of what was the construction as on the date of the undertaking. And then the judge brings in the legal proposition on the basis of which he comes to the impugned conclusion. Your Lordship may see what it says. As discussed supra, in the order dated 2710, this court categorically held that the petitioner cannot.
We get it that without recording evidence, this finding could not have been recorded that after construction, after undertaking, whether you carried out any construction.
Well, yes, that is one. I am saying the learned single judge comes to the conclusion that the permission was cancelled. Therefore, I could not have made a construction because it's illegal construction. The construction could be illegal.
No, so what is your
Contentious.
Your case is that 6/9/21 you have not made any construction.
6/9 I have not made any. And my lords, subject to what your lordships may say, I am willing to have a technical engineer appointed today to show that the construction laying on that property at the
What
date of
stage of construction on 6/9?
I filed the photographs which your lordships would find at page 136. From page 136, they are not the best of pictures to have, my lord, but these are the pictures filed. And this is the state of affairs. Your lordship may have a technical engineer to come examine and talk about the age of the construction because that is the story. And this is criminal proceedings. While I believe, my lords, that upholding the dignity of this court is paramount. And I have...
Where are the actual photographs? See, these are copies like blurred, this thing. Actual photographs.
They are filed, I am told, in the file. They are in the file. Along with the
Which
writ petition.
file?
It is in the writ petition file. It's in the writ petition file. I don't think
Writ.
the file would have come to your notice.
Well, you could have annexed those photographs also, another copy here.
There's no date. There's no date of the photographs. Lordship may only notice.
Kindly come to page 137, my lords.
Wait.
Mr. Reddy, one thing only at
But-
this stage. What is the material to show that he has raised any construction after 6/9/21?
Please notice one thing in para 50, what the learned single judge says.
Hmm.
He says, you make it deliberately vague. What is the stage of your construction as on the date? when-
No. So, see, Mr. One thing,
Yes.
broadly speaking, contempt there has to be a willful disobedience of the order, right?
In fact,
One
if you-
minute.
Yes, I'm so sorry.
So, and as a quasi criminal proceeding, therefore, this thing. So, don't you think his stand is that he has not raised any construction after 6/9/23?
But
One minute, listen to us, Mister. Please listen.
Please.
What you then we are always we can hear you.
yeah,
So his contention is that I have not done anything after 6/9/23. You say he has done it.
I'm not saying so. What I'm trying to say.
No. That's why he has violated the undertaking. That's why you have filed contempt,
Yes.
right? Against him.
Yes,
So your case in substance is that he has violated the undertaking and raised construction after 6/9/23, correct? How we don't want him to go scot-free. But before he is punished, this fact has to be established whether after 6/9/23 he has raised any construction. This you will agree.
First thing, my lords, if he gives such an undertaking, the affidavit filed with the writ petition must state, as has fallen from the bench right now, what was the stage of the construction on the date of the undertaking. In the writ petition, I should say, I have laid a slab in the writ petition. I will not conduct any further construction is what I would say. He doesn't say that. Further, my lords, the counter of
So,
the
Mr.
state.
But in that contempt, now that question ought to have been considered by the bench accepting the undertaking. And you should have pointed out that no, this way undertaking is vague. Please do not accept. One minute, the undertaking was accepted by the bench which dealt with the matter, right?
And they continue.
Now, Mr. Reddy, same thing, right? Please understand. It boils down to same thing, right? He is saying these facts of the matter is he is liable for contempt provided he has carried on construction after 6/9/23. Correct?
Yes.
And he says he has not done so. You say he has done it. Now, how to determine this fact? You tell us what means we can determine this.
That my
By an independent person, you tell us who can find out whether he has raised any construction after 6th of September 23. He has said, senior counsel has said that this age of construction and anything, any expert person, you tell who should be that expert.
One thing, I'm glad your lordships are asking that question. The order of the court was not based on my submission or his admission or anything like that. The municipal commissioner of Narsingi municipality, in the counter filed by him in the contempt petition, himself said there is a violation of that. They are continuing with construction. And himself says, I only demolished a part of the building, doesn't say why he demolished, why he did not demolish the whole. Then he files another counter manner. Just see the manner in which the municipality is saying. Now, municipality is an impartial body, my lord. We were both interested. Municipality said that the construction.
No, that's why we don't want you, we want an independent person. That's why we are asking municipalities also respondent in the rate petition.
Yes.
So we do not want parties involvement to this issue.
No.
You tell us who will decide, which independent body, Mr. Reddy, will decide this. You can decide.
I will just come to that question. Lordship may see only page 79.
No. So are you opposing that prayer? Do we take it that you are opposing that prayer of ascertaining this fact by an independent expert body?
But I have no one to oppose because it's a contempt appeal. The matter is between the contemptor and the court.
Ah.
I am only bringing a relevant fact before your lordship.
So we think like then if you have no locus, then we will pass an order. Who will do it, Mr.?
Because
You
when
are saying that you can't oppose, then will ask him. Before he goes to jail, we would like to satisfy ourselves that he has violated the order.
one small submission. The commissioner of municipality is a responsible authority. Page 79 is a sworn affidavit. At para 5, he says there has been a violation.
There is, Mr. This finding has not been recorded with reference to.
Very interesting.
He has.
Finding has not been recorded with reference to his stand by learned single judge because he says so.
No, he has done so.
Learned single judge said,
His lordship says.
no, where he has said that para 5 municipality has said, therefore I am holding that construction has taken place beyond 6/9/23. Please tell us
Yes.
which paragraph of the order.
Page 79 for a moment. Your
No,
lordship
no. Order of learned single judge.
referring to that particular.
Yes.
It's not there, but lordship.
Not there. That's what we are saying, that you are now you cannot like Mohinder Singh Gill sort of situation. No, you are trying to, that order is passed, then you are trying to supplement it by no, they said here in para 6 that the learned single judge has not seen.
What I'm trying to suggest.
It is not the basis of passing. We are not letting him go scot free.
And the
We are directing, you tell us, better you tell us which independent body can examine it and give us a report in a sealed cover, an affidavit stating that whether or not construction has taken place on after 6/9/23.
Well, it's
6/9/21.
HMDA
6/9/21.
21.
and several undertakings given thereafter, my lord. It's not one undertaking. Several undertakings are.
This order only refers to this
One.
6/9/23.
Yes, but several given.
Whatever.
Yes.
Punishment.
HMDA, my lord, this land falls. HMDA is a good authority, my lords, who may do so. That is my response.
No, HMDA who? not a clerk of HMDA.
Commissioner HMDA will be the appropriate
Well, may
authority.
I suggest?
Commissioner is what? IS officer?
May I
It
suggest?
should be an IS or conferred.
I
No,
have-
but he may not have the technical knowledge.
Some engineer from the GHMC or the HMDA. Your lordship may
You
ask,
tell
Narsingi municipality, my lords, commissioner.
let it be outside of that municipality
outside the.
or that municipality.
Because finding is they have connived with each other, my lord.
No, that's why.
Reasonable reason, let justice appear to be done.
Independent body, no. GHMC is independent. You think it's independent?
May not speak. We could have somebody from the JNTU, man. A professor, JNTU.
GN. JNTU. So this JNTU,
Yes.
Jawaharlal Nehru Technical University.
Technology University.
And who will, should be the person? HOD of Civil Engineering Department.
May I suggest this, my lord? So your lordship may say the HOD or a delegate on behalf of the HOD
Whatever.
to inspect and submit a sealed report to the.
HOD. We will
The
request.
reason
HOD.
I tell your lordship,
We are
why
sure that if we ask HOD, he will do it.
that should not make a difference. I'll leave it.
Right, Mr. Reddy?
Or I'm submitting.
No, the all contentions are open, but we, as you said, that it's a matter between contemner and the court.
That's the
So
principle.
before, yes, of course, correct principle you have said.
Keep citing.
No, before sending him to jail, we want to be satisfied. See if this report comes against him. The order stands simple. This appeal under section 19, mark their presence. This appeal under section 19 of Contempt of Court Act 1971 has been filed against an order dated 4th of September 2023, by which the appellant has been found guilty, of violating the undertaking dated 6/9/2021 furnished by him to the court, as well as order dated 27/1/2021 passed by learned single judge in WP number 13491/2021. The learned single judge has therefore directed the appellant to suffer imprisonment for a period of 6 months and to pay a fine of ₹2,000. Paragraph. We have heard learned senior counsel for the parties to some extent. Full stop. The dispute. Full stop. The issue whether or not the appellant has violated the undertaking furnished by him to the court on 6/9/2021, as well as the order dated 27/1/2021, in turn depends on the fact whether or not the appellant has carried on any construction in the premises after 6/9/2021. Full stop. The paragraph. The aforesaid pivotal issue needs to be adjudicated. Therefore, in order to ensure just and proper adjudication of the controversy, we direct that head of the department of Jawaharlal Nehru Technical University. We request you, don't direct. We request head of the department of Jawaharlal Technical University to visit what site? To visit.
Site located at.
You give number
We'll
particulars.
give the details. We'll give it to the
Details.
stenographer.
So and so,
Lordship will find it at page 1A.
whatever,
We'll
you
give
give
it.
it.
We'll
So and so, because he may not know where to go. So and so place. The head of, needless to state that head of the department. You will remain present, right?
My lords.
The head of the department shall issue a notice to the parties for date of inspection, and thereafter shall carry out the inspection. In the report, it shall specifically be stated whether any construction has been carried out after 6/9/2021. The head of the department of JNTU is requested to submit his report in a sealed cover. head of the department along with a civil engineer, right? Head of the department
Department of
along
civil
with
head of the department will be for each department. Civil engineering.
what we have said, head of the department of,
Civil engineering, your lordship.
no, head of department of, in beginning we have read civil engineering, right? Of Jawaharlal Nehru Technical University, right? Yeah. So and so. Thereafter you write the head of the department of Jawaharlal,
Jawaharlal Nehru Technological University.
Head of the department civil engineering works so and so of university shall be entitled to take along with him a senior professor of civil engineering department for the purposes of. So then the report shall be submitted by head of the department and such senior professor who may be nominated by head of the department in a sealed cover before this court on or before next date of hearing. So cost of inspection needless to so and so whatever. It is also clarified that so and so a head of the department of civil engineering department of so and so shall notify the cost incurred in carrying out the inspection, and the appellant shall bear the expenses. In the meanwhile, it is directed that impugned order insofar as it directs imprisonment of the appellant for a period of 6 months shall remain suspended till next date of hearing. However, the appellant shall deposit has already deposited a sum of rupees 2,000 by way of fine. The aforesaid deposit shall be subject to outcome of this petition.
One small
List on what date we should list?
any early date.
Early. 1 week he will take, no?
Your lordship is
You are in a hurry to see that he goes.
It's just very close to even the High Court.
All right. What date? No, we are just thinking.
not the sparrow that carries the report.
My lords, if your lordship were to see the manner in which they have violated.
26 September?
Yes. 26.
List on 26 September. Then they see before that you say copy of the registry is directed to ensure that copy of this order is served on so and so a head of department whatever today itself for compliance. Then list on 26/9.
A small submission, my lord. Now that my lords have given this order and an inspection has been directed to be done, my lords, that property, my lords, we don't know what the builder may do with regard to that property by the time of the inspection. Should the municipality be in some control over the possession of the property? I'm only putting it to the bench.
No, see, Mr.
We don't know the
Then contempt is only of 6 months and 2,000. 2,000 is deposited, not contested. Only question is whether he goes to jail for 6 months or 3 months or 2 months, or if at all whether he should go to jail, number one.
Yes.
And if he goes to jail for how much time? That's the only question.
They may demolish or do something with the property. By then is my only concern, my lord. Just to purge them of this contempt.
In the 6 months.
That's a relevant thing which my lords may consider.
So the report shall contain, you have written, no madam, report shall contain
Some
what you have read, please read.
property should be in some way.
Submit a report stating whether you have not written anything. Construction has been carried out by the appellant after 6/9/2020. That's what 6/9/21.
Yes, ma'am.
Not 23. 21.
Obliged.
Let's see.
Deeply obliged.
But I'm for appellant, but the appellant hearing is the petitioner.
No. See, your application seeking permission to raise construction has been rejected. Under which act you made the application?
My application is that
Which act?
I'll submit. My application is not seeking permission, my lord. My application is
To construct boundary wall.
to the endowment authorities to construct a boundary wall to the temple in order to protect the temple land. That's what is my application.
This is a PIL, right?
Not PIL, my lord. This is a writ petition which I have filed before single judge.
You are temple.
But I am an association which maintains a temple connected to the main temple.
No. So you are virtually the temple authority. That means no. Why the temple is unable to this thing take up the issue of construction of boundary wall? This is what is your locus? If you are not temple management, what is your locus to see that boundary wall?
I am a person having
They
interest.
have, huh?
I am a person having interest. Your lordships may
You are a person.
having interest. My
What interest?
lord, your lordships may once peruse two.
No. This the court has written in your praise at page 19 that you are a person who has encroached 1,000 square yard of the land belonging to temple and seeking a direction to temple to construct. But it doesn't want. Are you concerned? It's good, no, that you can encroach further land. It's open land, so you have encroached right now 1,000 square yards. Encroach another 1,000 yards. Why should
I'll
you?
submit. My lord, if at all, if I am an encroacher, my lord, they are at liberty to remove me. It's
You have a liberty to encroach, but they must take recourse to law.
if I am an
You
encroacher, my lord,
you encroach without taking recourse to law, and they should initiate proceeding in law and file a civil suit for during your lifetime and should not be able to get a decree. This is the argument.
lordships, my lord, from 2015, my lord, I've been.
No. So you see, Mr. Two questions straight that you are not a person belonging to management of the temple, right?
Yes.
And you want the temple to construct a boundary wall around its property. Why? How are you agree? If they don't want to construct, how?
Some miscreant.
Which statutory right of yours is affected?
Your lordships may once punish section 218 of Endowments Act. 218.
That no, Mr. You have understood?
Yes.
If the temple does not construct a boundary wall around its property and you are a neighbor, assuming for a moment, we don't know whether you are a neighbor or not, you have not told. You are a devotee of the temple.
Yes.
Which legal right is affected?
My lord, being devotee, my lord, if temple land is unprotected, my lord, then I am aggrieved, my lord. My interest is involved, my lord, is my respectful submission.
So then this thing, 1,000 square yards land you have encroached. This is the finding.
I haven't encroached any land, my lord. Your lordships, for a moment, my lord, your lordships may grant.
Where is the letter dated this thing? 9/5/23.
9/5/23, page 39, my lord.
Where does it say that you have encroached?
Lord, it's the representation given by me, my lord.
So where from learned single judge has got that you have encroached 1,000?
My lord, that is at page 80, my lord.
Page
80, 80.
80.
On my application, this is the reply which they have given, my lord.
Yes.
Lordships at page.
So you know, Mr. The discretion of this court under Article 226, jurisdiction of this court is extraordinary and discretionary.
Yes.
We will not invoke this jurisdiction to help an encroacher.
Yes. Lord, I am not an encroacher, is my submission, my lord. My lord, it's the authority.
What did you do when this was given to you on 6/6/23? That survey number 352, file an affidavit that you are not.
Yes. Yes.
File an affidavit.
I'll file an affidavit to that extent, my lord. My lord.
No, that you will file an affidavit to the extent that you are not
Yes.
you have not encroached any of
Yes.
the temple land.
Yes, I'll file that.
Huh?
I'll file that.
File an. And don't think that merely by filing an affidavit things would yourself.
Lord, file.
This thing and straightway from here your client will be sent to somewhere else. If it is found that affidavit shown in by you is incorrect, right?
Yes.
Right.
For a moment.
Yes. No, first file an
Yes.
affidavit.
Well, for a moment, I'll take your lordship to the
Nothing.
earlier order, my lord.
First file an affidavit.
Yes, yes.
We will not hear you for a moment until this. First you say that I am not an encroacher of the
Yes,
land
yes,
belonging
my
to temple. Number two, what legal right is affected? How petition at yours? These two questions you have to first answer that you have not encroached, then only we will this thing. The situation is in your favor. Keep on encroaching the land. So long as, because boundary wall is not there, encroach another 1000 square meter. This is what the temple land is meant, right? Temple land is meant for society to encroach. And you are doing perfectly that way.
That the authority says something.
Learned single judge has recorded this in
moment.
1 minute. This we are asking you to file an affidavit
Yes,
first.
well,
This
before
is-
that, my lord, I'll
There's
file my-
nothing before that. First affidavit, then we will hear you.
Yes, I'll.
This intra-court appeal is filed against an order dated 19 July 2023, passed by the learned single judge, by which writ petition preferred by the appellant has been dismissed. Paragraph, learned counsel.
Words, I am appearing for respond number 2 to 4 in this matter. In the Supreme Court, connected matter is pending. The system generated, tentative system generated date is 9/10.
Or list. Same order.
Same may merge with the other similar type of petition.
It will be listed along with that.
Yes, Lordship.
13%.
10% lordship. Same may be it is listed with the 24116 of 2025.
List along with WP number 17973, 17978, and these numbers, right? Of 2023.
Computer generated tentative date is 9/10/2020.
9th October, Lordship. It is for the notice, Lordship.
Issue notice, right? Issue notice list along with WP numbers one. Yes, next.
May please, my lordships.
Ah,
Lord, challenging the notification, my lord, issued by the.
what is the stage of recruitment, Mr.? This was 9 months ago.
My lord, now the written examinations are to be scheduled, my lord.
Scheduled when?
My lord, from tomorrow, my lord, is what my instructions are.
Tomorrow?
Yes,
What? Tomorrow means what?
my lord, 12th of September.
No,
Tomorrow is 13th.
13 September.
Tomorrow is 13th.
13 September. for recruitment to the post of junior lecturer.
Yes, my lord.
What is your challenge?
My lord, on two grounds I am challenging, my lord.
Ah.
First ground is, my lord, that the reservation under rule 22 and 22A is not being followed, my lord. To demonstrate that, my lord, I'll take your lordships to page number 34, may I request, my lord.
That's why we admitted for hearing notice.
My lord, may I request one thing, my lord, subject to what lordships may kindly say, my lord.
No stay.
My lord, I'm not asking for stay, my lord.
We are rejecting your prayer.
My lord, I'm not asking for stay, my lord. There are
Then-
another two more applications which I have filed, my lord,
What
for your
direction?
lordship's consideration, my lord.
What direction?
My lord, IA numbers I filed. My lord, IA number 3 is, my lord, with regard to directing them to restrict the rule of reservation for women to 33% in terms of 22A.
This all
2 and
this
3.
can't be done by way of an interlocutory application after 9 months. After this, you have woken up from deep slumber.
Can I request
So-
one thing, my lord?
Nothing.
Any kind of recruitment, my lord, is subject to your lordship's
So that
final
is-
orders, my lord.
That is always there, even if
Yes,
we don't say. We are not inclined to grant. This thing, the petitioner has challenged the validity of the notification dated 9/12/1992, by which process of recruitment for the post of junior lecturers admitted for hearing. Notice. Yes. Notice whosoever is appearing will accept notice and then say that remaining respondents. Yes, issue notice to remaining respondents, unrepresented respondent. Next. Yes.
Your lordship had disposed of, she was
This judgment, right, covered in this petition. Where is that judgment, madam, yesterday's? 3-2. In this petition, comma, the petitioner has impugned the validity of the rule 3 within brackets small Roman 2 within brackets small d within brackets small e and small h of Telangana. Bar 2023 and other connected matters. Paragraph for the reasons assigned in the aforesaid common order judgment. No, common. Don't write judgment. Common order. This writ petition is also dismissed. Yes.
very clear.
Yes. What?
The petitioner secured a seat in MBBS.
Mahavir College. So you didn't get yourself admitted. What can be done? Second round of counseling. Are you ready, entitled?
Lordships, they say that lordships are not, because they could not, if the students who are not earlier reported to the college who brought said are not eligible for second rounds of counseling. That's the
And until unless you challenge that rule, what relief do you get?
lordships. Here is a
Yesterday that showed.
GO 125, my lord. In case the
lordship.
candidate seat is allotted, my lord, fails to report to the college, my lord, it will be made ineligible for further round of counseling.
Lordships.
Rule, have you seen that?
Yes, lordship. One submission, lordship.
No, have you seen that rule?
I have seen the
Then
two
what
lordships.
can be done? How can we, please appreciate our predicament. We cannot grant any relief in contravention of rules and exercise of power under Article 226. If you want, you will have to challenge the validity of that rule on whatever ground available to you.
Lordship, only ground what they urge is, Lordships, we are.
Rule, Mr. Give the rule.
Lordship,
You are not understanding only ground, that ground. Mr. The
This-
rule does not permit you to appear in the next round of counseling.
Rule does not permit me, Lordship. At the same time, Lordship, now.
You are seeking a relief. Please understand, Mr. You are seeking a relief contrary to rules. We in a writ petition under Article 226 cannot grant a relief contrary to rules. If you challenge the rule, then it's okay. You will have to, for that purpose, amend the petition. We don't know. We give the rule. Rule 125, GOMS.
Actually, they have issued this notification yesterday, Lordships, yesterday night.
Asking you to appear.
So press registrations were given. Earlier, Lordship, they even blocked the press.
Hey, what is this, Mr.?
Lordship,
What
in
is
that
this?
they stated the candidate should not.
But what happens if they say the university wants to consider it, can, but we can't do it. Mr. What is it?
That is with regard to those candidates, my lord, who could not register, my lord, earlier, my lord.
What is this? We don't know what he has passed on.
It's
Probably the Mr. His 1 minute. His case is that he had earlier, he was offered a seat in MBBS course due to his this thing, financial status or this thing problem. He could not this thing mobilize the funds to pay the fee. Now probably he wants admission to BDS course. That his counsel is not telling us, but we have read it.
No,
So correct.
we have only for.
You should say so, Mister. This is we are not seeking admission to BDS course.
Lordship,
We have to find out to plead the case for you. What is this?
Lordship may pass order, my lord, will,
Pass on.
because, my lord, as per rule, my lord, is not entitled for further round of counseling, my lord.
Which rule?
No, GO 125.
Where is the 120?
just now have passed on your Lordship, the first clause 1, it says.
No, Mister. This.
Clause 1, Lordship, this is a notification they have issued for further counseling, mop-up round counseling. First clause, candidates who were allotted seats in previous phases of counseling and have not reported or discontinued the course at the respective colleges are not eligible for.
So you are not reported, right?
Lordship, we have not, I got seat, but have not reported Lordships to the college because I could not mobilize the funds of 11,55,000 because my.
What can be done? We have all the sympathy, but for you. But what can be done, Mister? Our predicament is, Mister, we are bound by rules.
Lordship, now.
This is C rule 120.
Lordships, now the same is reiterated. Lordship, now I just want for BDS Lordships. BDS it can be permitted Lordships. I am not opting for MBBS. MBBS Lordship, they say that the seat, I am arranging for seat block because I.
This, Mister, please, this is really a pity, Mister. We are repeatedly telling you third time that there is a rule against you. You have not annexed it. You have not read it. You have not challenged it. And despite being told 3 times, you are not even curious to know what is, let me see what is the rule. You are just saying, they are saying, they may say anything, Mister. They may say that you are lineal descendant of King George V. Will you become,
Lordship, the rule.
Mister? He can say anything.
Lordship, that is the.
Please understand. We are third time we have told you. What will be done? And this, what he is giving is already, this says the same thing, not in his favor, that he should be permitted to appear, nothing. Mark it, what can be done?
Same thing, Lordships, what the rule stated as been issuing a notification. Lordship, I mean, now I'm seeking for a BDS Lordships, not for MBBS. So my case may be considered Lordships. If for MBBS Lordships, I'm ineligible. Now I'm seeking for BDS because the course tuition fee of BDS is much lesser than MBBS. That is the only submission.
You can, we can ask them to decide your representation. That's all, nothing beyond this. According to us, you are not entitled to this relief. If you want us to pass an order, we will do it right away.
It's the
Third time, Mister, we challenge you. No relief contrary to rules can be granted by this court under Article 226. You don't appreciate what can be done. Let poor students suffer because you are doing like this. We only hope that the student is watching your performance online and he or she understands that court was repeatedly telling you to look at the rule which you refuse to do so, and therefore we have to dismiss the petition. Fine.
Barring me, I have forwarded your lordship. I have already addressed the mail lordship. They have not acted upon it. Lordship.
In this writ petition, comma. Fine. What can be done?
Let my
On the question of admission in this writ petition, petitioner who is an aspirant or aspirant seeking admission to MBBS stroke BDS course has prayed for the following relief. Quote. Paragraph. No, delete. Everything delete. Or on the question of admission. Even the notification issued issued by the university for exercising web options for mop-up phase of counseling for admission to MBBS and BDS courses say that the candidates who have been allotted seats in previous phase of counseling and have not reported stroke discontinued the course are not eligible to exercise the option. Full stop. The full stop. Paragraph DPT. It's too late now.
Lords, that,
You should have said in the beginning.
Lords, that is, I just want to make it, I addressed the mail lordship. Let my representation may be considered lordship for the BDS.
You should have said in the beginning, as you have been doing in all other cases, you have chosen to argue this case, Mr.
No, lordships. I just
Sorry.
want your lordships put me a question with regard to the rule lordships. I could not say that. That is the reason.
You should have said that, sir, it be disposed of in the direction to decide representation. We would have done so. We told you that you go to them because they can do it. We can't. No, sorry.
Lordships.
No, sorry.
Lordship.
You must realize your mistake. Yes, next.
Because your Lordships have put me a query with regard to the GO of Lordship 126, I could not go into that aspect, Lordships.
Fine, whatever aspect. Yes.
But the plaintiff secured a seat under MBBS.
Same order.
But my request is this,
Same.
my
You learn from his mistake. Either you say at the beginning representation, otherwise the order, same order in your case. You have also been given a seat in first round of counseling. And the rule debars you, you have not challenged the rule.
May I make two representations? May I make two submissions? My first submission.
No, please argue. I mean, feel free to argue. Then don't say like him that I was not arguing and I was just asking. You want to argue, right?
First, my only two submissions. My first request is, I was directed to report on 2/9/2023. But because
conjunctivitis.
Because of dengue, from one, I could not
conjunctivitis.
I could not.
Many people are not reporting. They are unable to upload their indicate web option on account of this thing, conjunctivitis also.
I have also annexed the medical certificate of the
whatever.
Page 14. But if your lordship so pleases, this may be considered. But in alternate to this, may I request, I have also made my representations at
that representation
40 and 41.
That they will look
that
in.
may also be considered.
Fine. Also that will only be considered. Or if you want an order on merits, most welcome. Just now we have to only change the name of the college and the order applies to you also.
My representation may be considered, my request.
This petitioner who is an aspirant for admission to MBBS/PDS course for in the state of Telangana has filed the petition seeking the following reliefs. Paragraph. The petitioner was granted a seat in first round of counseling in yes, Mister. What are your instructions? To contest. Oh. Yes.
Your Lordship, Malord, doesn't find inconvenient. Kindly have the next week, Malord, for hearing. Yes.
Next week?
Maybe Tuesday or so, Malord.
Tuesday, 20th September?
Yeah, any day, man.
Learned Senior Counsel for Respondent Praise for a short accommodation list on 20th September 23.
Interim order needs
The interim order granted on earlier occasion shall continue. 12-13. Let this petition be listed before a bench in which one of us, right lordship's name is not a member. 12 and 30.
The interim order may be extended.
Yes. Yes, yes.
Freedom fighter,
Yes, madam.
freedom fighter. Freedom fighter pen.
Ah, freedom.
No evidence.
Find my synopsis, my last.
That is fine, madam. What can be done?
Lordship.
You advise your client what? We find it like 90-year-old person. You did not fight this thing. You did not fight for the country in anticipation that after the country gets freedom, the government will formulate a policy of grant of pension and the government will not give it to me. Then I will file a writ petition in the High Court. Why at the age of 90 years he need all this? He has done it for the country. He knows that he participated in the struggle. If he has participated, he knows, right? And the God knows. What is this petition? We feel, I mean, like bad in dismissing your writ appeal.
My Lord.
We feel bad about what to do. There is no recommendation by Hyderabad Special Screening Committee, and you have filed after 5 years.
There
What
is,
to do? We explain these two things. We will decide. We were definitely not there. We have not seen a petitioner participating in the freedom struggle.
I please your Lordship. There is.
Neither primary evidence, not secondary evidence.
My Lord.
Yes.
Lordship, there is a recommendation, my Lord, in page number 95.
Recommendation.
Yes, Lordship, 95.
Is it Mr. Praveen Kumar?
Recommendation,
Page
may not
number
be second year.
95, my Lord.
Also may not.
No. The learned single judge has knocked her out on the ground that
Yes.
there is no recommendation. If she says there is a recommendation, then probably a case of consideration may arise.
But it is a certificate issued by the freedom fighter.
Huh?
Page number 95, my Lord.
See, Mr. Praveen,
Well,
is there a certificate?
no.
No.
Right.
Tell madam what.
Lordship, may kindly see the page number 95, my Lord.
Yes.
After the verification of the collector verified the report and sent to the state government recommended his claim to the first respondent, my Lord. He clearly stated in page number 95, based on the recommendation of the collector, are called, my Lord, in page number 95. Recommendation of the collector, Khammam district, necessary following documents, certificates produced by freedom fighters in support of their claim, whose cases have been recommended by the erstwhile HSSC, grant Central Freedom Fighters Pension.
So where is your name?
This letter has been received by the appellant, my
Where
Lord.
is your name? Your name in this.
In next page, my Lord, page number 96. He has received letter. Appellant has received letter.
Mr. Praveen Kumar. Yes. We'll consider this. Heard on the question of admission, learned counsel for the appellant submits while inviting the attention of this court to communication dated 14/10/2003 issued by Government of Andhra Pradesh to the Deputy Secretary Government of India submits that the erstwhile Government of Andhra Pradesh had forwarded the claim of the petitioner for grant of freedom fighter pension. However, the aforesaid aspect of the matter has
Obliged.
yes.
I beg to appear, your lordships.
What happened?
Your lordships.
LPG.
My lord, yes.
Yes. What
Has been
On the
filed.
last occasion, your lordship was
What have you
to direct me to
Ah.
file an affidavit, my lord.
Ah.
I filed an affidavit with all the internal correspondence as well as the guidelines, my lord. Your lordship had
So,
told-
see, Mr. Why have you not cancelled LOI of respond number 4?
yes, my lord. He has sought for extension of LOI, my lord. the rules provide for extension, my lord, because your lordship had asked a question, my lord, if we did not extend the time for the petitioner or the appellant, how could we have extended the time for the fourth respondent? The petitioner's case, my lord, the appellant's case was that she could not get permission, however long she took, because it was too close to a railway track. But in the instant case, my lord, of respondent 4, it is a case of
When
not
have you filed an affidavit?
yesterday, my lord.
You have got a copy?
Yes,
We
Your
don't
Lordship.
have the, madam. Next week then, it's not there, what is learned counsel for the,
May I request this week, Your Lordships, because there's a lot of bad faith in the affidavit he's filed also. I can explain that to Your Lordships as well.
no, but it's not before us, madam, that's the
Yes.
problem. You can explain fine, but
Yes, Your
it
Lordship.
has to be, we must be able to appreciate what you are
Yes,
explaining.
yes,
Ah.
through Your Lordships.
Learned counsel for respondent number 2.
2 and 3.
Submits 2 and 3 submits that in compliance of the order dated 18/8/2023. IOCL has filed an affidavit yesterday, what 11/9/23. However, same is not on record. Office is directed to trace the same and place it on record. List on 14/9.
Yes, Your Lordships.
Day after.
Yes, Your Lordships. Yes.
Obliged.
Lordships asked me for placing of a synopsis, my lord, which I have placed it.
Synopsis.
So, please, Your Lordship, notice.
What synopsis, madam?
Your Lordships wanted to hear it finally, my lord.
Finally?
Heard it for admission, Your Lordships. In the same time,
Madam, this is not being heard finally. I mean, you are under a wrong impression.
so I've not heard it. Wanted to hear, I said.
No. Okay.
I would submit the
You
fact.
please argue on admission.
Very well.
Why it should be admitted, tell us.
Yes. Lord, repetition is filed, Lord.
We have stopped hearing 2023 matters. We are hearing 98, 99, 2000 matters, right?
I do
Which is
I do find the difficulties.
So all matters you find out in your office and give a list. So those will also be listed.
Yes, I would have.
Yes, please. Yes.
Lord, the appeal is preferred by the writ petitioner, Lord, as against the orders of the Learned Single Judge, Lord, 4/1/2023. Lord, the facts in a nutshell is that Lord, petitioner before a lordship, the appellant before a lordship was granted for releases, Lord, in 3 phases, and all were amalgamated. Subsequently, due to the political pressure and other pressures, the areas were surrendered 3. So, the leftover area was only 7 hectares. But while that being so, there was a public interest litigation petition filed on the file of this honorable court that the quarry in pursuance to the judgment of the honorable Supreme Court, that in the Kokoman case, the quarry operations are being done by several quarry operators without obtaining environmental clearance. There was an interim order passed at 17/12/2012 by the division bench, directing the environmental authorities to take action that without wherever there is no quarry in the environmental clearance to stop the quarry operations. Therefore, the quarry operations were stopped from 17/12/2012 in terms of the interim order, and order is passed by the Pollution Control Board on 13/2/2023. When there were no interim, the petitioner has applied for issuance of environmental clearance certificate on 1/2/2013, and also filed an inspection. That it is pending before the SCIAA, the quarry operations are stopped to expedite the petition. But this honorable court also passed orders in WP number 28864/2013, directing me to pass orders on my application process within a period of 6 weeks. However, that was kept pending.
This order of determination was under which act? MMDR Act? Central Act? State Act?
State Act.
State Act. So order of determination, no appeal or revision lies?
I filed. Appeal lies to the state government because this is an order of the Director of Mines and Minerals.
So appeal was filed and it was dismissed.
Appeal, I also filed a writ petition. This honorable court directed them to pass orders within a period of 2 weeks. In the
So appellate authority passed an order dismissing your appeal, then you file a writ petition. So two things, madam. Do you have environment clearance certificate?
environmental clearance certificate.
Not required.
processed for the reason
Cannot, is not required.
it's not that, my lord. It is determined on 25/8/2018, it cannot be passed. But all the other proceedings are completed before the environmental authority. You'll also kindly see, my lord. All the proceedings were completed by 20th/12/2017. I've also made a representation to the assistant director and the director of mines and geology. Then all proceedings are completed and I wanted to get a certificate. But while that being so, I was issued a show cause notice. Not that I am not operating and I will not submitted the blood as regards to accounts and audit. I have complied with everything except only the submission of the environmental clearance certificate. And I have explained that this is the reason where I am unable to submit the environmental clearance. You will also kindly see, an order is passed without consideration of my representation, without meeting the grounds I have raised for. Relying upon the parallel box furnished by the assistant director of mines and geology. By a non-speaking order. But they just dismissed my revision. On the ground, without your Rakshas.
Where is the order?
Figure Rakshas.
Non-speaking order.
46. 46. Before that, madam, we may take a lot of slot. The determination order is 27/2018. 27/7/2018 is the application of the respondent number 5. And by 7/1/2018, not there is a grant in their favor.
What is non-speaking order? This runs into 3 pages. What non-speaking?
You'll also kindly see up to paragraph number 7 is the extraction of the contents raised by me. They extract whatever is raised by me, 8 year also kindly see. After hearing the contents of both the parties and taking the material made available, this is at page number 48. There are 2 important observations noticed related to imperial granites. When the bill was filed in year 2012, it impacted 400 plus granite quarries in Arspel and Granite. However, as per the order stated 25/2013 of the Honorable High Court in 2023, 52 units have already granted ECs and for 168 unit, ECs have been cleared to be issued certificate. I am one of this below. To the said quarry holders and further certain clarifications have been asked from 34 units and total number of soils filed for EC is 2. But imperial granites failed to obtain EC. Recognizing the consultants who got confidence from these area of the division petitioner got EC and conducting body operations, but the division petitioner failed to do so. Imperial granites has successfully attempted to transfer part of the quarries area to other companies on 4 occasions. Further, in the transfer application, they have stated that the new quarry is in a better position to do quarry as compared to them. These are nothing, they are not part of focus notice, not part of determination order. They are not part of the focus notice, nor a determination order.
No, you said non-speaking order. When then the reasons have been assigned. Now you have shifted the stand. This is not, madam. You said that non-speaking order. We thought that one line order. Now it has assigned reason. Now you are saying that you have changed your ground. That it is on a ground which are in respect of which no notice was served on me.
I did not say notice is not served. Did not meet the grounds of appeal submitted by me.
No. You said that it's a
Non-speaking.
Non-speaking. Then it's a speaking order. Elaborate, running into pages. We don't agree with you that it's a non-speaking order. If it would have been in one paragraph without considering contention, we would have understood. It's not the case here, madam. He is not a judicial officer who has been given training how to write a judgment. Please understand.
This 1 and 2 what is not a part of Shota, please for my answering. Now to take it from.
That's a different ground. That's what we are trying to tell you, that you are trying to shift the ground. Like once caught, then just immediately jumping to the next ground. First said non-speaking order, then we are saying speaking, then jumping to the other ground.
That would be my second ground.
So you first better, madam, tell us 1, 2, 3 grounds. Then you can jump easily from one to another. First ground is non-speaking order.
Second ground is the orders are not part of Chokas notice, not part of determination orders.
Grounds on which order is based is not part of.
So first notice of determination order as against which I have preferred the appeal.
So what are the, you have to then prepare a chart that these are the grounds on which show cause notice was issued and these are the grounds on which the order has been passed. Who will do it?
Do it.
What is the third submission?
The third submission is not the transfers are at the expense of the government due to certain political pressures, and it is not true that I have not operated, and I am one of this application for 165.
So you have carried out operations, right? Mining, acquiring operations.
Yes,
So have you paid the, this thing dues to the government for which you carried out?
that will not I have submitted my in my reply after in my reply.
Then you have to substantiate by saying, no, merely saying that I have this thing I have operated is not enough. If you have carried on acquiring operations, you have to pay the amount due to the government under. Have you paid? Where are receipts? What period?
I will submit, not along with it.
Then it is not, madam, like we are asking question, I will submit. Not like this. Why did you not submit before the authority? This not, we are only examining the validity of the order passed by learned single judge. It's not a fresh de novo petition where you can do whatever you feel like. The scope is confined to examining the validity of the order passed by learned single judge. Please appreciate. You are in an intra-court appeal, and as soon as some question is asked, I will say I will file. Why did you not, then first place you have to tell us why you did not file along with your reply to show cause notice, why you did not file before the appellate authority, why you did not file before.
Along with my explanation, I have sent all the.
So then say so that, why are you saying I will file? You say so that I have filed.
I would submit the receipt.
You file this thing. If you want to raise this, we hope that you understand what you are arguing, right? You understand, right? What you are arguing. So therefore, you will have to substantiate this. What else? Any other ground? 3 grounds?
Yes.
Mark the presence. When will you file? Tuesday? Monday?
So grant me 10 days for
Then we will not grant you any date. Fine. Then don't say that it is said that 10 days. So this date is listed, not listed. We are not giving you a date. This intra-court appeal is filed against an order dated 4/1/2023 passed by learned single judge by which Yeah.
In this matter, my lord, as per the direction.
Yeah.
A Gazette of India, my lord.
Huh?
A Gazette of India. Are wherein the rules framed by the government in respect of the Indian.
No. This is Mr. 1 minute. This appeal has been filed against an interim order.
Against the order by the land single judge, my lord.
By interim order, right? Are Mr. Interim order, right?
Yes, sir.
What is the interim order?
Page number 12, my lord. The operation.
What is it order?
Last paragraph, my lord. Order dated 27.
No, but you have not read it, right? You will read it here only. Otherwise, close the file if you have prepared the case. Close the file and tell us. Mr. You all people are here to assist us. You open file here only. We have read it. We are trying to tell you a simple thing. That the learned single judges declined to stay the process of election. The election have already been held. What survives in this writ appeal?
My lord, my humble submission. Kindly, my lord. Listen.
It is against an interim order.
Your lordship.
1 minute. It is against an interim order, right?
Right.
Refusing to grant stay of process of election.
Refusing, my lord. Lord, I approach this honorable court by invoking Article 226, my lord.
Then again we will have back to square one. Please come to page 12. We have not read the interim order. You read it for us because you don't know what is the interim order. Please read.
I know the land judge.
Please read it so that we also know.
At last parameter, order 27/7/2023 was passed by this court recording detailed reasons, and this court was not inclined to stay the election process. It was made clear that the results of the election of the respondent number 3 society would be subject to further order of this court. However, there was no impediment for the respondent number 4 to declare the results. Hence, the respondent 4 is directed to declare the results of the election held on 30/7/2023, my lord.
So election has been held on 30th July. The result declared.
The notification.
No. We are asking something, Mr. Please understand, you will have to answer our queries.
Yeah.
Because election has been held on 30th July.
Yes, my lord.
And result has been notified when?
Not notified, my lord. That's why they came before the.
No. So result of the notification, election has not been notified till today. No, Mr. Be serious. These people will land up somewhere else.
My lord, my humble submission, my lord. In this
we are asking you, we will hear all humble submissions, Mr. We are sitting here to hear you. But please tell us whether result of election has been declared or not declared.
Declared as per the order of this.
When declared? Date?
On, my lord,
Date?
8/9. I came to
8/9.
21/8.
21.
21/8/21. 23. I'm sorry.
21/8/20. Yes, please.
My lord.
What you want to argue now? Argue.
My lord, the petitioners filed the writ petition on 21/7/2023, my lord, putting the notification issued on 10/7, putting the election on 30/7, my lord. Prior to election 10 days, they filed the writ petition by bringing to the notice, my lord, irregularities and violation of rules, my lord. Kindly see at page number 15, my lord. The land judge, while hearing me.
Conclude in 5 minutes. We are only hearing you on admission.
Yes, my lord.
There is not a such great thing.
The land judge in the earlier order directed the respondents to proceed with the elections, and election, the results of the writ petition is subject to result of the writ petition, my lord.
So why it is wrong?
My lord.
Why this order is wrong? You have filed an appeal against this order.
An appeal, my lord, because the illegibility should not be continued, my lord, when I brought to the notice of this honorable court by invoking Article 226, my lord. dictating the elections now, by virtue of the orders passed, the statutory authorities are not expected to blood in disregard to the rule of law. Cannot further proceed. This is my humble submission, my lord. My lord, kindly see at page number 59 and 60, my lord, the counter filed by themselves, the respondent themselves. My lord, wherein procedures laid down for conducting of the elections are grossly violated by them, my lord, as per the submitted by them, my lord. As per the counter submitted by them, they admit they had committed mistakes. How they will proceed further, my lord, in case? My lord, a minimum respect to the rule of law, that is my lord, the duty of the statutory authorities. Otherwise, there will be, Lord, if this situation to be continued, my lord, there is no respect to the rule of law. A point to point, a rule is prescribed, my lord, that has to be adhered. In total violation, my lord, wherein the district collector for a district, my lord, the governor is for the state, and the president of India is for the country. In their auspicious presence, if this illegality is continued, my lord, illegality as per the counter of themselves.
No, how, what president of India, what he was not, she was not present. No, she was not president of India when the election of this society. What are you saying in presence of president of India? The argument.
I'm not saying that.
You said president of India, prime minister of India.
We bring to the notice of the honorable governor, madam, the irregularities committed.
We don't know, mister. We are concerned with the validity of an interim order. Anything else?
Madam?
Anything else?
That
This intra-court appeal is filed against an interim order dated 8th of August 2023 passed by learned single judge in WP number 10097 bar 2023 by which in a writ petition preferred by the appellant's former learned single judge held that the result of the election of Indian Red Cross Society Hyderabad district branch
the writ petition within a time frame, my lord. At least, my lord. At least the time frame, my lord.
Yes.
May please, your lordships.
Who is appearing through video conference?
Yes, my lord. I am appearing through video.
Oh, we are unable to see who is appearing.
I am MRS Srinivas, my lord.
Huh?
MRS Srinivas.
No,
Counsel for the
you are not visible to us.
I'm sorry, my lord, because some
Probably this thing must be off.
no, my lord, video is on, my lord, from my end.
Ah, but we have not switched off camera. But still, there is some problem with so we can't see you.
I'm sorry, my lord.
Ah, what?
My lord, in the last occasion, lordship directed the matter to be listed along with item number 19.
Well, item 19, I appeared, my lord. In fact, your lordship have granted me an interim order on 7th August 2020.
Both are arising out of the very same.
Yes. Yes.
Both are arising out of the very same order, my lord.
Ah.
My lord, the petitioner.
Your case is similar to that of the appellant in that other case.
Very same order, my lord. Some of the petitioners have filed the item.
Give item. So you want a similar order, right?
Yes.
Item 19.
19.
Yes.
Learned senior counsel for the appellant has appeared through video conferencing. Learned senior counsel for the appellant submits that WA number 765/2023, which arises from a common order passed in WP number.
WP number 9407.
WP number 9400
00 of
2023. It is further 2020. It is further submitted that the case of the appellant is similar to that of the appellant in WA number 765/2023, in which an interim order has been granted. Paragraph in view of court's submission. Issue notice to respondents. Then meanwhile, directions contained in the order passed by learned single judge shall not be made applicable to the case of the appellants in this appeal as well.
Obliged.
Admitted for appeals are admitted for hearing. Yes. 18-9.
Interpret 718 of 2023. Same order will pass already. So all the three have to go together.
Acha, list for analogous hearing along with WA 718 of 2020. Yes.
Obliged.
Yes, next.
Wait, please, Let's
counter.
just recall when the matter came up last time.
Submission. Yesterday, university has given notification. Yesterday, university has given notification, my lord. For those candidates who could not register earlier, my lord, they can get registered. This is a notification.
So
Yesterday, a notification is given permitting all the petitioners to
you can, so your grievance stands redressed.
stand.
Learned, mark the presence in this writ petition, the petitioner inter alia has prayed for following relief. Paragraph. Learned counsel for the respondent submits that yesterday's what date 11/9 or that on 11/9/2023 the university has take that you are looking that on so and so university has issued a notification in by which it is by which the qualified candidates who were not registered in response to earlier notification have been asked to get themselves registered for admission to MBBS/BDS courses for academic year 23-24 under management quota. Full stop. It is further submitted that the petitioner can apply. Petitioner shall be permitted to apply under the aforesaid notification. Paragraph in view of aforesaid submission made by learned counsel for the university, the grievance of the
But this concerns
Ah.
a heritage monument for Hillfort Palace.
you made some submission last date.
Yes, my lord. What has happened now, my lord? The precincts committee has been constituted, my lord, in
There is
2020.
National Academy of Construction.
And they filed a report, my lord, suggesting that the entire building has to be either removed and reconstructed or an alternative decision to be taken by the state. State, my lord, in turn has
No, so what is demolished? The whole building has to be demolished.
and reconstructed is what the National Academy of Construction has suggested. But subsequent to which, my lord, the precincts committee has been formed. The GHMC commissioner is the chairman with the members. But 14th is the meeting. 14th is the meeting to take a decision, my lord, whether to proceed, my lord, further in the matter. So
You are saying that the recommendations of this National Academy of Constructions have been placed before a committee of GMC.
consisting of Greater Hyderabad GHMC, headed by the GHMC commissioner, along with the members. I filed the affidavit.
All right. Mark the presence, learned. Mr. Harendra Prasad, learned special government pleader attached to the attached to the office of learned advocate general submits that the recommendations made by the National Committee of Construction shall be placed
They are placed before the Greater Hyderabad Heritage and Precincts Committee.
Greater Hyderabad Heritage and
Precincts Committee.
Precincts.
May I please, your worship. This,
What suspension, Mr.
no, let me say this.
This is listed for interlocutory.
Yes,
IA 1 of 22, 2 of 23.
yes, not
What
this.
stay you want?
Your worship may kindly see not the petitioner completed more than 4.5 years tenure of the Sarpanch plot. At the fact and the tenure is completing by 2-3 months not.
No, the election has already
Yes,
been
Lord.
held.
Your worship may kindly.
Election has already been, somebody else has joined.
No, Millard, the election of the petitioner has been set aside by the OP Millard on wrong premise of law.
No, Mr. This thing, 2/8/2023, respondent number 6 has assumed the charge of
Yes.
the post of Sarpanch.
Yes, Millard, that
Correct.
without giving, within span of Millard 6 days only, Millard.
Yes, we have got the order. Anything else, Mr.
Worship, kindly see, Millard, the order.
What stay do you want, please?
You want the
Are you, 1 minute. Are you continuing as Sarpanch today?
Your Lordship may kindly see, Millard, till the Millard, the petition was dismissed, Millard, and was continued, Millard. Your Lordship may kindly, Millard, the petition was dismissed in the on 27/8, Millard. Within span of Millard, 7 days only, Millard, the collector has, Millard, given charges to the.
He has given you an opportunity to be more rich by continuing for
At least, Millard, 30 days.
That's a real time, right?
30 days,
Again,
no, Millard, 6 days only.
Not satisfied with service you have done for 4.5 years.
Kindly see, Millard, he has performed, Millard, 30 lakhs of work, Millard, that is still pending. At the verge of, Millard, the tenure, Millard, he has been removed, Millard. Your Lordship, kindly see, Millard, your Lordship is kind enough to satisfy and admitted the petition, Millard. He has not, your Lordship, there are no allegation of antecedents. The antecedents are clear, Millard. He has, Millard, put the nomination form.
No, it is our mistake, Mr. That on the day of admission, on the day of admission, we did not pass orders on your IA. So you have to take the trouble of mentioning and then arguing today. We will pass an order on both the IAs today. We will not commit anything else you want to go argue, please tell us.
Your Lordship, kindly similar, your Lordship have seen the nomination paper, kindly see that.
But we have seen this is not being finally decided. It is on IA 1 of 23 and 2 of 23.
Yes, Your Lordship.
So what stay should be granted, you should be allowed to continue as Sarpanch.
By suspending
Yes.
this order of the.
Learned counsel for the heard on IA number 1 of 23 and 2 of 23. Learned counsel for the petitioner submits that the election of the petitioner for the post of Sarpanch was set the facts is no case for grant of stays made out as the order dated 2/8/2023 has already taken effect, right? Has already taken effect and respondent number 6 is functioning on the post of Sarpanch. Therefore, IA 1 of 23 and 2 of 23 are dismissed. Next.
Counter, my lord, the hearings are complete.
Huh?
Hearings are completed, my lord. Counter is 5.
Yes,
But,
we'll admit it. What is to be heard, right?
Admitted.
Admitted. Why it has come for then?
LRTP applications are pending.
What suspension and this?
Yeah, senior citizens lordship, because it is pending since 2018. Their health condition is.
No. What is IA 1 of 18, 3 of 18 and
Order was passed, my lord, on the first day only interim order was passed. On the first day only interim order was passed, that was complied with, still they
which
filed it
interim order?
on the first day of the admission.
Arey, you are the person who is not paying maintenance to your parents, right?
Your lordship.
Correct.
I have paid maintenance, my lord, I have paid.
No. So why give
The court also passed on the first date of hearing an order of 10 lakh rupees to be paid in 4 months. Even that was complied with. In spite of that, he filed a contempt application.
Hey, he is your son, right?
Yes.
Huh?
Yes.
So what is it? Why do you want to? Has he not paid 10 lakhs to you?
Actually, it was paid in 2018. The shop is at
So you want every month 10 lakhs to be paid?
It was the only source of income for his lordship. His other son died in the accident. After that, he stayed in his house.
Mister, you must amicably resolve this dispute. Amicably resolve the dispute. Who is your father?
Yes,
We
madam.
don't want to go into this legality. This is what the court said.
Yes, madam. Last time.
You appear this thing, no. Appear before a mediator.
Yes, madam.
We'll request Mr. Justice Kodandaram to you appear before him, both of us. Right, let us find out. We are there. And if he has got it, my judgment is also there in Karnataka. I have written section 23 of 2007 Act. Didn't get it.
I have not taken.
Section 23, we have written a judgment.
And item 24, for the respondent number, three, item number 24. I am for the respondent always Archaeological Survey of India. And in 25 doublet. All these appeals for arising out of flood.
I have heard in the first of the three writ appeals, but I am for the beneficiary. So let the learned TSG first argue the appeal, my lords, because there's an interim order in his appeal.
Yes.
All right, this has to be heard, right?
Yes.
We'll admit it. Please, whosoever wants early hearing shall file an application, we'll consider. Appeals are admitted for hearing, interim order granted on earlier occasion shall. Yes.
Subject to lordship due, he is not the party before he will not to make a submission below. Subject to
No,
lordship.
file an application for urgent hearing if you want.
In fact, lordship express that involve the urgency of lordship.
No urgency. Nothing, we have stopped that practice. We have corrected ourselves. Everybody is entitled to correct ourselves. We have decided that there is no point in hearing 2022 and 23 matters and keeping old litigants at bay. You see the list, what hearing party.
This relates to awarding of contract and
if you are in a hurry, please.
station basis.
You
Yes, no.
if you have 1 minute, if you are interested in early decision, same rule apply.
Yes.
File an application for urgent hearing, we will consider it and fix it.
Lords, there are three appeals. He files
All appeals are admitted.
an appeal only in one appeal. Doesn't file.
We have not decided his application shall be considered at the time of
Yes.
hearing.
Yes. Yes.
But will be completed.
Right.
Yes. Yes, Mr. You have to file counter. All the matters, no counter.
My lord, say, counters have been filed, my lord, your lordship can, may kindly take up one writ petition.
Huh?
17, 11, 7, 17.
No. Counters have been filed. Pleadings are complete.
Not pleadings are complete. The request is for early hearing by the both
So
states.
then we will hear it. Today we are admitting it. Then.
My lords, the short issue only will, my lords, it is like, my lords, an interpleader suit, akin to an interpleader suit, my lords. The matter issue is between the two states as to interpretation of section 51. My lords, issue is very simple, my lord, your lordship may consider any short date, my lords, because the amount which is otherwise entitled to by the state of Telangana.
I have no difficulty, Lord. Deposit the whole amount. Both states have taken 50% each. Lord, I am just having only to observe this, Lord. It's a fight tussle between the two states as to who is entitled. So they are in a hurry. I mean,
Mr. Advocate General.
My lords, in fact, Mr. Sriram, whether he is appearing today.
Yes, my lord.
Not appearing.
State government of AP, my lord.
AG office is logged in, but nobody is appearing.
In fact, on the last occasion, he was here to proceed with the matter.
Yes.
Yes, my lords. Subject to.
Not there.
This doesn't take much time at all, my lord. Simple issue.
Give this thing synopsis, give it.
Yes. Your lordship may post it after a week's time, my lords.
I will not. My lord, if your lordships are kind enough, subject to what the learned at convenience, will, my lord, I kindly permit me to give a date, my lord, so that I am representing the learned advocate general for the state of Andhra Pradesh.
So which date?
My lord, kindly.
You prepare, Mr. Advocate General, please prepare a synopsis. If but it is but short, then please prepare a synopsis.
Yes, my lord.
Please prepare.
Yes, my lord.
List of date and whatever your proposition, case law, paragraph number, that's it, 2 page.
My lord.
So we will be able to move faster.
Yes.
Kindly give me 1 minute time, my lord, so that I'll give the date after talking to the learned advocate. I'm extremely sorry for that. Please give.
Please tell us.
I'm great.
So any date would suit you. So please tell us, Mr. We are waiting. Go out. I will have to go, right?
Yes, my lord. I have to find out and
find out.
Apologies.
27 to 36.
Okay.
Petitions are admitted for hearing, taking into account the interim order granted on earlier occasion shall continue. DBS said interim order should continue. Yes.
Item 27, there's one IA 1 of 23, there's a delay in compliance with the order of this honorable court. My lords may consider condoning it.
20?
In the item 27, that would be 32617 of 22.
What condonation?
Condonation in complying with the order of the honorable
All right,
court.
hold on IA. 27 item IA 1 of 23 reasons assigned in the application duly supported delay condoned IA is allowed.
If there is a delay in payment delay. Payment, if there is a payment in delay, my lord, it attracts interest that need to be paid.
But that you can, I am requesting this honorable court to condone it.
Then if it's no, we thought that delay in compliance of office objections.
No, not that. It is
No. then IA suitable orders on IA 1 of 23 shall be passed on at the time of hearing of the petition. Yes.
My lords, there's a connected matter in the batch which is not listed.
Next.
My lords, there's a connected matter in the batch which is not listed. Even that matter may be tied along.
Which matter?
Red petition 3366 of 2016.
Yeah, but why don't you like, you are waiting for this thing to be mentioned, right? WP, you say list along with WP number?
3366 of 2016.
Mr. Advocate General, he is saying WP 3366 of something is connected. We don't know what is it.
My lords,
You know what is the dispute about?
yes, my lords. Item 29 in the case of the very same petitioner, there is another red petition which is not listed, my lords.
That can whatever order, my lord, your lordship is going to pass will apply.
It follows the
bank
same
of
pattern.
cases. It's a loan.
No, but
Tax
he is listing, he wants his petition to be listed. But the unique way, right, at 12:55, somebody else's case.
My lord, when the next time when the batch comes up, if it can be listed, my lord, it's the same subject matter.
If it is connected, same matter, my lord, it can be listed along.
List along with WP number.
3366 of 2016.
You could, Mr. But file an application, do something. This is not. Yes, all right.
Yes.
Yes. Why it was passed over?
Your lordship want to hear the
audio. Yes. Where is that?
What is this?
Between petitioner number 1 and respondent number 2. Respondent number 2 is inspector.
when they are talking to the citizens. In a sense, it need not be so harsh in a way that is suggesting that he's trying to threaten the petitioner, which cannot be accepted. I feel that it's better the contemnor comes before the court and answer the questions. He has a very long discussion, which is not supposed to do it. It is not within his jurisdiction.
Like
When he will appear, tell us.
your lordship may fix the date.
When?
But I will also file, your lordship, I'll also file the transcript of the conversation, what is taken also, Lord.
Yes, please. We have, keep it here on this.
I think he's here, Lordship. Morning he was here.
Let him file the transcript.
I'll file
We
transcript.
are not doing anything, right?
Already it is there, Lordship.
This appeal under section 19 of Contempt of Courts Act has been filed, by which the learned single judge has held the appellant guilty for willful disobedience of the interim order dated 5/7/2021 passed in WP number 14622/2021. By the aforesaid interim order dated 5/7/2021, the appellant as well as other the learned single judge has found the appellant guilty and has sentenced him to undergo 3 months rigorous imprisonment and a fine of ₹2,000. Paragraph. We have heard learned counsel for the appellant to some extent and have heard the CD also, which is a conversation between the appellant and the petitioner number 1 in the petition, namely respondent number 1 in this appeal.
Yes.
Respondent number 1 in this appeal. Full stop. We after going through the CD, we paragraph at this paragraph. At this stage, learned senior counsel for the appellant prays for adjournment in order to enable him to file the transcript of the CD for our perusal, as well as to produce the appellant before us. List on
After tomorrow, Lord.
day after is 14th, no? 14/9. Who is saying day after?
Yes.
You will get the transcript by day after, right?
I'll file, and also you may request your lordship may suspend the sentence.
1 minute, no, not like this. Let him.
After tomorrow, Lord, 3 days time, so that I can file in 1 day in advance, so that the transcript in the registry.
So you wanted on 14/9, right? You want it on 15th September, Friday.
Right, you're much obliged.
15/9/23.
One submission, Lordship.
Meanwhile, may I request your lordship may suspend this?
Nothing meanwhile.
One submission, Lordship. Transcripts already I extracted entire thing in contempt petition.
Have you filed the caveat?
No.
Then why are you interfering? It's a matter between us and the contemner.
Sorry.
Contempt is not of you. Contempt is of the court, right? We are dealing with him. Yes. 37.
Wait, please.
How this petition? 37. We were hearing some bunch, no, yesterday. So how this petition has come up in between?
It's an old matter.
No, it's obviously, but what had happened that we were taking up a bunch of petitions yesterday. So, and the additional whatever she was arguing. You already know, madam, with that matter. So, Mr. Shall we take it up after we finish the bench? Immediately after this. Some in between.
Of dates as well.
You are given?
Yes.
Please wait. As soon as it is finished, we'll take it. After this, you call this bunch. $38 to. Yes, madam, have you
My
prepared?
lord,
it?
I have prepared a note, my lord.
So first, which WA?
WA.
Yesterday we told you, right?
Yes, my lord. My lord, these are
Oh,
my,
madam, there is no submission with regard to why only 15 lakhs should be granted and
my lord, as of the judgment of the learned single judge is concerned, my lord, it is an equitable judgment which has been passed. Only my
so you have to give, assign us reasons that we told you yesterday
I have
that why the prayer in the writ petition should not be granted and only 15 lakhs is sufficient.
the prayer in the writ petition, my lord, they are asking to regularize the land, but the judgment says that they can be evicted after they are paid 15 lakhs for 5 acres of land each and the cost of the developmental charges. We go with the order of the learned single judge.
You don't want to justify the order of the learned single judge by arguing anything.
My lord, learned single judge
Why
justification.
justify?
My point which I have given here, my lord.
Not
Actually,
given anything.
yes, my lord, the will be a burden to the state exchequer, my lord, if the
Burden to state, then why did you not file an appeal?
appellants cannot be unjustly enriched. My lord, that did not happen, my lord, because
Madam,
I have stated, my lord, that it will be.
give that
appellants will
this
be-
thing, you gave some history of the society. What?
My lord, it is with your lordship.
Where is that history of the society?
I have passed on yesterday.
So writ appeal, no argument, right?
Writ appeal, my only submission is this, my lord, that your lordships under 226, my lord, you are evaluating the correctness of the judgment of the learned single judge. My lord, your lordships, in your lordship's purview, my lord, can consider the interest of the government also, my lord. It will be a loss to the exchequer of the state, my lord, to pay.
Madam, why did you not file an appeal? Loss of exchequer and all? Can a respondent argue in an appeal? If you are aggrieved by the order passed by the learned single judge, why you did not file an appeal?
Not at that point of time, I do not know what transpired.
No. What transpired, therefore you will argue.
No.
And can we tell us as an officer of the court, can we entertain that argument?
No.
Without filing anything, can we say that the order passed by the learned single judge in his appeal, can we say order passed by learned single judge is wrong and therefore writ petition is dismissed?
Cannot.
That, what are you arguing?
My lord, I'm only submitting, my lord, your lordships are evaluating the correctness of the judgment of the learned single judge. In that purview, my lord, the interest of the state also to be considered because it's a large extent of land, my lord.
Mr. Harendra Prasad, one thing we want your assistance. Madam is arguing since yesterday. What has happened is in these bunch of petitions, the petitioners were ex-servicemen. They participated in whatever and came back to Hyderabad, encroached the government land or whatever. They claim that this land was allotted to them by a cooperative society, right? All this is done. Then they approached the learned single judge and sought regularization of the land. Learned single judge held in their favor that they were entitled to allotment of land, ex-servicemen, so and so, all that. But instead of regularization, they said that they were in possession of approximately 5 acres each. So the East learned single just said that instead of regularization of land, 15 lakhs should be paid to them at the rate of 3 lakhs per acre, right? Now, against that order of learned single judge, this gentleman has filed a writ appeal saying that everything is held in my favor. The relief of regularization ought to have been granted instead of payment of compensation. State has not filed any appeal. State has accepted the order passed by the learned single judge. Since yesterday she is arguing that the allotment itself is bad. So that's why we want your assistance. When in an appeal preferred by the appellant, which has been accepted by you, we hold that the writ petition deserves to be dismissed with cost of 25 lakhs.
The absence of appeal by the state.
I mean, repeatedly since yesterday she is arguing, and despite this being told, it's not that twice we have told her, please make her understand that this submission cannot be made. We are asking her to support the submission that payment of grant of compensation is justified and the land should not be regularized. She is not giving any reason for that except arguing that allotment is illegal. Please make her understand. We have tried our best since yesterday. We felt, at least I felt tired, so I sought your help. Please tell your colleague that she cannot argue this and no justification. Repeatedly we gave a suggestion that now the land in their occupation on account of development long back has come for urbanization. Like you cannot now permit agricultural activities. All this we are telling her, she is not arguing anything on those lines and is arguing that allotment is illegal. What should be done? Shall we write her submission that allotment is illegal and dismiss it, reject it by saying that this question can't be raised?
No appeal by the state. There is no appeal by the state.
You have accepted the judgment and she is telling us, I don't know what happened. We also don't know what happened. How can we find out why state has not preferred an appeal? She is saying, I don't know what happened. So we also don't know what, we are not concerned with what happened.
In view of the law, my lords, now the assignees are also entitled for compensation for the occupation of the land. But the Lord single judge having granted compensation, my lord, the state is now required to, my lord, submit.
No, but now we said that in with reference to subsequent events, you have to justify. The argument is not coming up. Mr. People at relevant 25 years ago, 30 years ago, we're in some possession of parcel of land that has come within the urban agglomeration. It is meant for urban use. We cannot, other public purpose, they cannot be permitted to carry on this. All she is not arguing. She is saying allotment is illegal. What do we do?
Well, I would respect.
This is the level of assistance, Mr. Prasad.
I would
We are
respect.
sorry to say.
I would respectfully submit, but considering the agglomeration now, it's having changed, the land nature of land having been changed, and also the fact that
This all yesterday we gave her time. Despite that, she is arguing, I don't know. Just now in your presence, she said, I don't know why appeal was not filed.
I deeply apologize, my lord, because it was not filed.
Yesterday only we told you.
True,
If you don't get it, what can be done?
should I have it?
They should say that this land is within urban agglomeration.
But what?
Mr. Do you dispute that this land is not within urban agglomeration?
Has come already.
Under urban agglomeration.
It's come already at the time of.
Correct, correct. We understand now. We are asking you now it has come under urban agglomeration. What is its use in development plan?
I only say this.
Land held by you, what is the use? This is all. It
is now, I'm told, not being put for the transport, road transport corporation, but all this.
What is that? With reference to use in development plan, you should have pointed out that this land cannot be used for contrary to development plan. Agriculture is not included in development plans. Therefore, 15 lakhs compensation we will pay.
Now strategic rural development plan has come, right? The area development, it's an area falling under the HMDA limits.
Where is the land?
But it is Jawahar Nagar, just 10 kilometers from. 10 kilometers from Secunderabad city.
what is its use in development plan?
Metropolitan Authority, my lord, undertakes this, my lord, about grant of layouts and all. But now, my lord,
So it is within the limits of Hyderabad.
Yes, my lord, that is not, there cannot be a dispute about it.
Correct. What is the use, Mr. as per development plan? It agriculture purpose.
Already, it is not the case of state government.
No, we are asking you.
No assignments are being made in yes.
Mister, court is entitled to take note of subsequent events, right? While deciding your claim for 15 lakhs, even though they are not arguing, but we have to take it up, right? So we are asking a question to you. Subsequent events the court can take note of. They may not be arguing because she wants to help you. Therefore, she is not arguing. She is deliberately arguing a point which can't be raised. So what can be done? So, but you tell us under HMDA, Mister, it is within HMDA limits. What is the use to which the land has been put under the development plan?
I'm not aware of the purpose, but as of now, it's in our position where we haven't raised any constructions or
right.
But the zone
You are carrying on agricultural activity. No, in future, but learning signature is held.
Compensate more under the need also, my lord, even the inputs are entailed for compensation is one issue.
No.
But now, my lord, having
Learning signature has held that they are entitled everything to land, etc., being ex-soldiers. Mister, that is exactly the argument that if the entire judgment is in my favor, my entitlement, learned single judge is found, then why restrict it to compensation? The direction should have been for regularization. That is the scope of the appeal. Please understand. And you are not substantiating it that why 15 lakhs is justified compensation.
But may I request for a day's deferment?
The date it is going on, madam. She is arguing this. Today is the second day when she has given us revised sort of things. Ask her. He has long back he has concluded and everybody has adopted his submissions. And now he wants to make 4 submissions in rejoinder. Right? See, we remember everything.
But I'm instructed, but subject to, but they are not the ex-servicemen who are allotted, subject to correction.
Order passed by learned signature, please see.
Order passed by learned signature also.
Please see.
Basing on the long-standing possessions.
I am not the conscious.
Kindly go to page 20.
Yes. Right. Mister, only on the long position.
27.
Merely on the basis of this thing, you are in possession, you have got an order of compensation.
Lord, may I say this, my lord? My lord, the assumption.
Yes.
Running page is 66.
Petitioner. Where's 33? 34 page 27 is page. Internal page 27. Yes. All right.
Page 65 and 66.
Fine. Right. Yes.
My lord, submission is that all, my lord, a question may arise, my lord, as to how all these appellants, all the ex-servicemen are exactly in 5 acres of land identified and they're how as to how they encroached onto this land. But if I may say, my lord.
Yes.
My lord, if I may say, my lord, then the exist.
Yes.
The policy which existed then, but the state
What
government.
is your right? First of all, tell us.
My lord.
What is your right in respect? The learned single judge is not for you. He has only held. You have encroached the land and continuing. allotments, etc. is bogus. That is not, you have not set
Under
up
the
that.
policy that government had earlier, Molot, once somebody applies for an assignment, if they're entitled, Molot, under BSO 15, or they're entitled to occupy such a land. Molot, that's a policy of the state, Molot, pass on BSO 15, which is applicable to this case also as per the assignment
But
policy.
pass on to them also, us, them also, us, give. But that's not your case. Can you set up a new case in writ appeal? No.
Molot, I'm not setting any new case, Molot, as to.
This is argued by you in single judge.
Molot, single judge, Molot,
Why you have, if the contention has been negative, will you tell us? That if you are entitled under this GOMS, why he has said that no, nothing can be granted to you?
Board standing orders, Molot, this page 61, internal page 61, Molot, clause.
No, you are not landless and poor person. You are a member of a cooperative society, and cooperative society has allotted land to you. Please understand. This is your case. You cannot go back upon landless and poor person.
Molot, I'm not landless for Molot. This is for Javans. This is for serving and ex-servicemen, Molot.
Mr. The whole case was that a cooperative society, defense cooperative society was constituted for benefit of Javans. The land was assigned to the cooperative society. Cooperative society in turn allotted land to you.
All right. Yeah.
Right? So you have to stand by your allotment by the cooperative society of land to you. This is the case. You cannot fine. Anything else?
Or learn single judge also rejected that contention that my name did not figure out in the appellant's names did not figure out in the original list of allottees by society. What the learned single judge held is that this policy itself is for to benefit ex-servicemen. I read that portion of the order, my lord.
Of course.
But para 65, page 65, my lord, the learned judge has also recorded.
Which internal page you tell us, because
this is
number.
Vacate stay petition, which the vacate stay petition of the state, my lord. Vacate stay petition of the state, page 65, running page 65. But the query which has fallen from my lords, the query which has fallen from the bench, my lord, kindly see me. Para 2 of page 65. It is an undeniable fact due to rapid urbanization. The twin cities of Hyderabad and Secunderabad have grown by leaps. This is the finding recorded by the learned judge, which I am trying to rely upon now. To bring it to my lord's notice, there was urbanization as in the date of the order being passed. Kindly see, my vacate stay petition.
Same, right? Page
65. 65. It's part of the
order of the single judge.
Kindly see, what the learned single judge record.
Yes.
It is undeniable fact that due to rapid urbanization, the twin cities of Hyderabad and Secunderabad have grown by leaps and bounds in recent years. Government extended the municipal corporation area to the areas which were covered by as many as 12 municipalities around the twin cities and constituted Greater Hyderabad Municipal Corporation, Hyderabad Urban Development Authorities in process of being replaced by MDA. The land in occupation of petitioner falls in Greater Hyderabad Municipal. This is the finding recorded by the land judge. Area and also the metropolitan.
All right. Yes.
Yes. But my submission is that, Molot, first I was referring to the ground, Molot, on which my name was not included in the society. Molot, that is at page number 24 of the writ appeal, Molot, which is internal page of the 18, internal page 18 of the judgment. As regards the third ground, may I just read, Molot? As regards the third ground of rejection, the same is equally irrelevant because the inclusion of names of the petitioners in the list submitted by the society is not a criteria. The managing committee of the society was superseded in the year 1968. The land was resumed under GOMS number 17 dated 5/1/1976. It specifically envisaged in the said GO that the land was resumed. The land so resumed shall be disposed of by way of individual assignment to the ex-servicemen for whom the scheme was originally intended on priority basis. For this omission and commission, the society lost its credibility, had become defunct, and the land was resumed from it. Therefore, there could be no rationale in respond number 2 insisting that an applicant for assignment should have been sponsored by such a discredited society. Indeed, neither GOMS number 743 nor 1573 made sponsoring of applicant by the society a condition
of eligibility for assignment. The fact that the petitioners were members of society is not in dispute. The further fact that they're all ex-servicemen is also not in dispute. Therefore, whether their names were included in the list sent by society or not is wholly irrelevant to judge the eligibility or otherwise of the petitioners for assignment. Therefore, this ground cannot be sustained. My submission to Lordships is twofold. One, the policy the government had earlier is that once you apply for, once you're eligible, prima facie eligible for an assignment under the policy, you're entitled to occupy that land. That is what the BSO says.
And the person decides his entitlement, right? You will say, I am entitled to occupy Court Hall 1 and then occupy it, then apply it to GO, under GO, that this Court Hall 1 be allotted to me. Because prima facie, I am entitled, you decide. Something, right? Yes. You are ranked trespassers.
Which land which was set aside for assignment to ex-servicemen. This entire 6,000
you came up with a specific case that these lands were allotted to us by a cooperative society. That issue you are unable to prove. Now you are changing your stand by saying that I am under this policy, that policy in writ appeal. Correct? What else? That we will examine. What else?
Second, solely to persuade your lordship.
When you said scope of the appeal is only confined to Mr. Regularization of land, that's it.
Assignment.
Argued, right?
Assignment of my. The other criteria the learned single judge went was market value or the price of the land escalation. With all due respect, that may not be a criteria of consideration. The reason that
you don't want compensation, right?
I only say this, in 2020, I'm not drawing parallels or seeking parity. In 2020, a serving officer was killed in action. A state government, under its policy, assigned 700 square yards of land in Banjara Hills, road number 10, which was worth about 20 crore. The worth of the land or the area of the land was not a criteria for government to consider assignment. In 2008, learned single judge took that into consideration where government as on 2020.
You should all be given land in Banjara Hills, right?
I'm not
for cultivation.
I appeared in the matter. I appeared in that matter.
Yes.
I appeared in the matter.
But you have not lost life in the action. You are still surviving. Right? How can you compare yourself with an officer of Indian Army who lost his? You said, fine, next now. What is next?
Correct. Only to set out that.
All right, next submission.
Or within urban agglomeration, there is no.
Next submission.
In 2020, we're in 2023, order is of 2008, when 15 lakh compensation, assuming that it
will. No, Mr. You are resident of some village.
I did this the same place, all the appellants.
Urban agglomeration only, you want land in urban agglomeration only, not at some village.
Since the policy meant that they can occupy that land, they've occupied that land. They've developed all that land all these years,
yes,
about 50 years.
Thank you.
Their entitlement, I only submit their entitlement at the point when they applied should be taken into consideration.
All right. Thank you. And what about Mr. Other petitions?
Other
Rate petitions, 38, 39.
Other petitions, my lord, I have filed a detailed counter in all the petitions.
Yes, madam.
I am appearing in item 39.
What do you say?
We have submitted our submissions.
But you are seeking the similar relief. What he is claiming in the petition, right? Thank you. Write down. Arguments heard. Cases reserved for cases are reserved. Yes, Mr. Vedanath. Your matter. 1 minute. 1 minute. We are not running away. Yes.
Item 60.
Whenever
it is convenient.
We can begin at around 2:30. Post lunch. You are appearing? Union. And where is the council for? Please tell, inform that we will take it up at around after post lunch session. Mr. Vedanath?
Yes. Your lordship's guideline.
Yes.
The previous case, my lord, if your lordship.
You wanted to say something.
One submission, my lord, if this is urban agglomeration is the ground, my lord, in any other village outside urban agglomeration.
That's what we asked you. You said, no, I want in urban agglomeration only.
My lord, your
Which
lordship,
village?
Well, may I get instructions on that, my lord?
No, not instruction. It may not be a matter of your choice. Wherever the land is, Mr. It will depend on subject of availability, and you are interested in agricultural operation only, right?
Yes.
Your lordship's permission, my lords. With your lordship's permission, my lord, item number 37 may be taken.
1 minute, madam. So, Mr. Prasad, supposing if they approach you with a prayer for allotment of land in some village, etc., you will consider? See, there are two options. Because you are supporting the order passed by the learned single judge, right? So you are ready to compensation of 15 lakhs to them. Subject to that, they will surrender. One option could be instead of paying 15 lakhs, consider their claim for allotment of available land in some agricultural area outside the HMDA limits in the entire state.
Subject to what my lord would say, my lord. Availability of land is one issue, my lord. Otherwise also, lordship will consider.
You can consider their prayer, right? In accordance with GMS, whatever.
On merits, my lord, my lordship believes that, yes.
So these two options, either you pay 15 lakhs or this thing, because 15 lakhs binds you, right?
But one more aspect I have also argued before, my lords, my lord. For the scheme which is left with the state now, state is only advancing the scheme, granting them the 2 BHK houses which are worth more than 30-40 lakhs today.
What do you think? Instead of agricultural operations now, is it better to shift into BHK accommodation? What do you feel? Lad, he doesn't want BHK. He may have several BHK houses.
15 lakhs is what the amount granted.
15.
In that context, I would.
So, Mr. Either 15 lakhs. One option is either 15 lakhs. The other option is consider his prayer as per his entitlement outside urban agglomeration. These two options, right?
Your lordship's kindly.
If as per entitlement has to be considered. Yes. Anything else, Mr. Yes, madam, you are saying something.
Item number 37, my lord. Maybe taken up on Wednesday, my lord.
This council was ready in this. We said that your bunch was this bunch. That's why we said that please wait. You want next week. All right. Today, probably that matter may go on 60. 37 list. You are appearing for appealing, madam.
Yes, I'm appealing for State Bank of India.
That's why we were. He's here, senior counsel. She's praying for. What do you say?
Since there's another matter.
Probably it may take some time. Learned counsel for respondent prays for short accommodation list next week.
Lordship's kindly.
Lordship's item number. Wait. We'll be coming back. It's not that you want to withdraw.
Item 41, my lord. That item 41, my lord.
Yes.
Because the name of the petitioner, my lord, was found in the list, my lord. He was in delivered possession, but he was not granted patta. That was my relief, my lord, in the said petition.
Okay. That we will consider.
And my lord, he died, my lord, I filed LR applications.
No. And see, there is an order passed by learned single judge granting 15 lakhs. That writ appeal, we are examining the validity of the view taken. Depending upon that, relief in your case will also be granted.
And one more thing, not because the collector.
You are ready outside the urban agglomeration?
My lord, any, my lord, if they allot, because 5 acres.
Outside urban agglomeration also you are ready to make an application as per your entitlement. Either we don't know what will be the thing. Yes.
Because they then collector not submitted report to the government stating that, my lord, he was in possession.
Item 41.
41.
All right, we'll see.
Your Lordship, Lordship, item number 18, learned senior appeared virtually. There's a
18?
condoned delay petition as well, which has not been ordered, Your Lordship.
Which case?
Item number 18 and 19, learned senior had appeared virtually. There was a stay on the impugned order. The condoned delay petition has not been.
All right, 18. Delay condoned, item 18. Delay condoned. How much delay?
Yes, Your Lordship.
Delay condoned. Heard on so and so delay condoned. Yes.
Much obliged.
What else? Yes,
Item 42, my lord.
42.
Is
Yes,
not-
please.
The land was assigned, my lord, by the government, my lord, government itself.
Ah.
And we sweep, my lord, direction to the response, not to issue deform partas in favor of the petitioner.
So item number 41.
We are reading
Which other case you said? Item?
41 is my case, my lord, wherein.
Hey, he is also saying 41.
No, 42, my lord.
42. So these two cases we will have a look separate.
Yes.
Yes.
Fine leave. May I make it? Item 48, 49, 51. Three matters I made. 48, 49 and 51. I believe this matter.
We will.
I believe this matter will take through the day.
We don't know. Ask Mr. Vaidyanath. He is standing by your side and siding. Ask him how much time.
I have inquired with them. They said.
Whole day.
Whole day.
All right.
So next 3 days I have some personal intervention.
All right. Anybody makes. Hey, these are 99 matters, Mr.
That's why I'm making mention. I'm sure tomorrow if my colleague makes a mention.
It will not be adjourned.
I have some personal inconvenience for the next 2 days. I'm not attending courts. 48, 49, 50. Monday, Your Lordship, next work. Friday.
18th. 48, 49, 50.
1.
You, 48, 49, 50.
51.
50 also, right?
Not 50 is not. I am not a
50 is connected, Mr. 49 and 50 is
49 and
connected.
50 are corrected. Yes. 4 matters.
48, 49, 50, 51. List on with the understanding, Mr. No adjournment, right?
Monday.
Monday. 18, 9, 23.
Sorry for the inconvenience.
Oh, 18.
I'm ready, but
18, 9.
Subject your lordship's leave, ma'am.
No, nothing, ma'am.
I'm passing on the brief note of case wise, ma'am.
Yes. Give the synopsis. Give the synopsis of whatever she did.
Lordships, extremely sorry, Millard. I'm sorry to make a mention before your Lordship. It pertains to medical admission, one writ petition, Millard, kindly have it tomorrow. Writ petition number 25459 of
When
2020.
have you filed it?
Today morning I have filed, Millard. Similar situated person has been considered and I am also in the same group as not been.
Don't argue now. If you are ready, we will, if Mr. Rao is not here.
Yes, I have already informed him, Millard,
Tomorrow.
with great respect to the samples.
Tomorrow, yes.
Obliged, Millard, deeply obliged.
Ah. Yes. Yes, madam.
May it please your lordships, and for the petitioner, my lords. My lords, this is a covered matter, my lords. The matter is pertaining to admissions of local and non-local candidates.
No, this is not covered, madam. Yesterday we have passed an order. This. Ah. So when were you treated as non-local candidate?
My lords, in the
When were you treated as a non-local candidate? 2/8/23?
yes, my lord.
And you have filed the petition when?
Today, my lords.
Today?
Yes, my lords.
Today is what date? 11/9?
Yes.
12/9?
12/9.
What were you doing from 2/8 till 12/9? We have already held.
My lord,
Similar petitions have been dismissed, madam. You yesterday order number. All right. Anything else, madam? Similarly covered, right?
my lords, I'm a permanent resident, my lords, but I was marked as non-local in the merit list, my lords.
So therefore, you are challenging the validity of rules, right?
Yes, my lord.
Now,
Yes.
fine. Dismissed. That order is, where is madam? Yesterday we gave it to some madam. Which person? So that paragraph and all that dismissed. All right. Yes.
Much obliged.
No, 60, no, one case.
Wait, please. Wait, please. The writ petitions, there are two.
There are two petitions.
Yes. One by state of Telangana, another by the.
Which one is by state of Telangana? Acha, this is
what? Writ petition 37,555. Yes, 37,555, 37,559. And both challenge that exhibit T1 dated 29th August 2022. An order issued by the Government of India Ministry of Power purporting to exercise powers under Section 92 of the Andhra Pradesh Reorganization Act.
order dated
29th August 2022. Page 37 of the state's writ petition.
So we take up this WP 37555, right? You are appearing in 375.
37599 pleadings, my lords may kindly refer to.
All right,
37559.
No.
588.
37599. Which page order dated 29/8/22?
Yes, page 37,
30.
exhibit T1
All right.
is the order 29th August.
Asked under section 92.
Yes. Of the AP Reorganization Act. And when the order says, whereas AP Reorganization Act 2014 came into effect from 2/6/2014, whereas Schedule 12, Section 92 of the Andhra Pradesh Reorganization Act inter alia provides as under existing power purchase agreements with respective discounts shall continue for both ongoing and projects under construction. For a period of 10 years, successor state that has a deficit of electricity shall have the first right of refusal for the purchase of surplus power from the other successor state. Whereas Power System Operation Corporation, POSOCO, in its letter dated 18/6/2014, conveyed that during the meeting held on 28/3/2014, APSLDC shall continue supply of power according to schedule in force as on 2/6/2014. In accordance with the decision taken, AP Genco supplied power to TS Discoms. Therefore, Genco supplied power, AP Genco supplied power to TS Discom. Whereas AP Genco had supplied power to Telangana Discoms post bifurcation. From 2/6/2014 to 10/6/2017, there is some dispute in regard to the period, but broadly it is correct. Under clause C2 of Schedule 12 of AP Reorganization Act, so the issues related to power supply use. Representations have been received from state of Andhra Pradesh that Telangana has not paid for the power supplied to that state from 2/6/2014 to 10/6/2017. Whereas there is no dispute regarding the amount to be paid for the power dues, the principal amount being rupees 3,441.78 crores and late payment being rupees 3,315.14 crores to be paid in addition to the principal amount as per the applicable provisions. This factual statement is also incorrect. Every right of one party entails the corresponding duty. Right and duty are co-joined, and as such, Telangana must pay the power dues to Andhra Pradesh for electricity supplied to them under the orders of Government of India, issued under the Andhra Pradesh Reorganization Act 2014. Each one of this is incorrect. Supply was by AP Genco to Telangana Discom, not by the states. The states have no obligation. And Miller, it is not supplied under the orders of Government of India. It is supplied pursuant to Schedules 12, para C of the Reorganization Act. There was no order of the Government of India. Therefore, Government of India, in exercise of powers vested in it under Section 92 of the AP Reorganization Act, hereby orders that the successor state of Telangana shall pay the due amount, as mentioned in this order, the successor state of Andhra Pradesh, within a time frame of 30 days. The central government is obviously cognizant of the fact that the dispute as between Genco and Discom is not a matter which can be resolved by the Government of India at all. There are separate provisions under the Electricity Act. And in spite of that, it says it is a dispute between the two successor states. So one dispute between the two successor states is purported to be taken up and disposed of without taking into account the dues from state of Andhra Pradesh to state of Telangana. Various number of matters are pending. Now, this is the order which is under challenge. Now, I must indicate that a large number of petitions, other petitions filed by the Telangana corporations against the Genco are pending. There is an order restraining order of the Telangana State Electricity Regulatory Commission restraining AP Genco from taking coercive steps for recovery, which has been challenged by them in a petition. No stay has been granted. That is not listed. That's not taken into account. There is a petition filed by state of Andhra Pradesh for comprehensive determination of the disputes in regard to sharing of assets and liabilities between the two states in the file in the Supreme Court in August 2022, in which notice has been issued and the matter is directed now to be listed on November 2023. These are some of the other petitions which are pending and reference to it, as I take my lords through the list of dates, I'll take my lord. But one single dispute putting to the payment to be made was supplied by the AP Genco to Telangana Discoms is taken out and treated as an interstate dispute, and power is sought to be exercised under Section 92, which power is not there. And the assumption, I have huge other claims that is not taken into account. Now, if my, yes, and my lord, this order, in my respectful submission, has been made, has been issued by the Government of India, though the matter was taken up in by the government in the committees set up for the purpose of resolving these issues, standing committee of the Southern Zonal Council in a number of meetings, and was to be taken up in a meeting to be held in 2022 September. Even before that meeting could take place, without hearing Telangana, though Telangana had been put on notice that we will be taking up this matter in the next zonal meeting, without hearing us, an order which seems to finally determine that issue has been issued on 29th August 2020. This is brought in short, Miller, the order. If I may place, Miller, the relevant list of dates. List to us. Twenty-second December 2009. Three power purchase agreements between Andhra Pradesh Power Generation Corporation and Andhra Pradesh Distribution Companies for 1/4/2006 to 31/3/2009. The relevant period comes within this. And Miller, this was at the time when the state, there was undivided state of Andhra Pradesh, but the agreement was between the generating companies and the distribution company. 22nd December 2009, composite PPA, Miller reference has been made where it appears. On 1st March 2014, Andhra Pradesh Reorganization Act received the assent of the President. 2nd June 2014 is the effective date on which Andhra Pradesh Reorganization Act started being implemented and state of Telangana came into existence. 2nd June 2014, Apex Committee, Power Coordination Committee was set up in accordance with the Andhra Pradesh Reorganization Act. On 16 June 2014, State of Andhra Pradesh unilaterally cancelled all the PPAs by letter dated of that date, 16 June, from AP Genco to Telangana Distribution Companies. 17 June 2014, letter by Government of Andhra Pradesh Energy, Secretary Energy, to Chairman and Managing Director AP Transport to schedule power in 65:35 ratio from projects located in AP. Additionally, the rescission of PPA did not have APERC approval. On 18 June 2014, which is a communication referred to in the order, impugned order, letter by POSACO to APSLDC conveying that APSLDC shall continue with the supply of power as per the existing scheduling procedure as per Andhra Pradesh Reorganization Act. 24 June 2014, meeting of Southern Regional Power Committee at Bangalore. where all participants except AP Transco agreed that scheduling of power from AP Genco, AP, Andhra Pradesh should continue as per Andhra Pradesh Reorganization Act. 11th August 2014, Common Order of Andhra Pradesh Electricity Regulatory Commission in OP numbers 14 to 25, directing State of Andhra Pradesh that withdrawal of PPAs is not valid and the PPAs cannot be unilaterally rescinded by AP Genco. At the appropriate stage, I will place relevant portions of this order. Telangana, 15 June 2014 to 31/5/2015, Telangana Discom floated tenders for short-term procurement of power for this period, as State of Andhra Pradesh did not schedule power from Krishnapatnam Power Plant. 11th August 2014 to 11th June 2017, despite Andhra Pradesh Electricity Regulatory Commission order dated 11/8/2014 and state load dispatch centers directions dated 18/6/2014, State of Andhra Pradesh did not supply power to the state of Telangana. They supplied some power, but not fully. And that I have set out. State of Andhra Pradesh did not supply 805.66 megawatt from Hydel Station, 862.24 megawatt from Krishnapatnam Thermal Power Plant, 560.5 megawatt from Hinduja Thermal Power Plant, from Srisailam Right Bank from 11/6/14, from Upper Sileru from 23/6/2014, from Interstate Hydro Project from 2017, from Machkund Dam from 2017, from Tungabhadra Dam from 2017, and thermal station. Due to this, Telangana Discom had to purchase electricity from the market at a very high cost and incurred an extra cost of rupees 7,354 crore, including interest. On 4th January 2016, letter from PTC India, that some of these may not be very relevant, therefore may skip these, that in regard to our having to purchase from other states and etc. That for the time being, I don't think it's very relevant. I will skip these and go straight away to the next page. Kindly come to 2018, middle of the page. AP Power Utilities filed company petition so-and-so in the NCLT for recovery of dues in regard to the power supplies and the bills that had been raised. This is withdrawn subsequently. Therefore, one means of recovery they adopted was by filing a company petition in the NCLT on the basis that we have not made the payment in regard to admitted dues. This was withdrawn by them. Then next, Telangana Discom filed OP number 59 of 2018 before Telangana State Electricity Regulatory Commission, and the Telangana State Electricity Regulatory Commission was pleased to direct the AP Power Utilities to not take any coercive measures against Telangana State Discom. This order, unfortunately, is not on record, but I got copies. I shall place them. There is after hearing the Andhra Pradesh Power Utilities, an order is passed restraining them. This order is challenged by the AP Power Utilities before the Honorable High Court, this Honorable Court at that time, it was one single court, Writ Petition 42577 of 2018. This, I believe, has been transferred to the Andhra Pradesh High Court and it is pending. Although, according to me, that transfer will be wrong because it challenges the order of the Telangana State Electricity Regulatory Commission, and the petition had been filed by the Telangana Discoms. So, at that transfer, I think perhaps as and when the matter comes up before the AP High Court, they may retransfer it because that is what has been happening. But it is still pending. No interim order is granted. So the order of the State Electricity Regulatory Commission restraining the AP Power Utilities, including AP Genco, from taking any coercive steps for recovery in respect of dues on the power supplied by GenCo to Telangana, AP GenCo to Telangana Discom is in force till date. In spite of that, they have gone ahead and moved the government of India as if it is a dispute between the two states. Now, and government of India is a counter affidavit, and the GenCo, AP GenCo in the counter affidavit says, no, this has nothing to do with the sharing of assets and liabilities between the two states. It is only in regard to supply of power dues, in which case there is a direct order restraining you from recovering. In spite of that, this is not even taken into account. Now, Telangana, 19th August 2019.
This order you have, Mr. Vaidyanathan.
Yes, I have.
Restraining them from.
Yes, OP 59 of 2018, I have the copies. Can you pass? Yes. I've got two of those. Yes. My lords, para 1 sets out the prayers made, and the facts are set out. Para 9, amidst the applicant stated that even after 4 years since the formation of state of Telangana, various issues including sharing of assets and liabilities and sharing of employees between power utilities in the residuary state of Andhra Pradesh and state of Telangana are not yet finalized and waiting for adjudication before various legal forum committees. Amidst these disputes between the power utilities of state of Andhra Pradesh and Telangana, AP Genco raised bills on Telangana discounts basing on generation tariff issued by present APRC on 26/3/2016 for the power supplied by the power plants of AP Genco to Telangana discom. Initially, AP Genco raised bills based on power sharing ratio proposed in TOMS number 85/2004, intentionally ignoring the actual schedule of power to applicant. This was objected to and requested respondent number 1 in this petition to bill only for actual generation. Applicant stated that without prejudice, any prejudice to prevailing dispute in respect of claim, Telangana discoms have paid rupees 3,886 crore to AP Genco on provisional basis, subject to reconciliation and settlement of dues at state level. Considering the fact that all these power utilities, that is AP Genco, TS Genco, AP Transco, TS Transco, are owned by respective governments of residuary state of Andhra Pradesh and state of Telangana. It is stated that AP Genco is insisting that the claims of AP Genco for the power supplied by them to Telangana discounts till October 2017 may be paid after netting of the power purchase claim of TS Genco against AP discount for the power supplied by power plant under Telangana Genco to AP discount. Applicant stated cleverly sidelining the final claims to be settled among all the power utilities at state level between two successor states in accordance with the provisions of Settle Act 6 of 2014. Then those are set out. And then will kindly now come to para 16 refers to various disputes pending, dues payable by AP Genco. Those are set out 1,391 crore, 3,096 crores, and para 17, 2,137 crore. These are all amounts which are pending. And para 19 refers to national NCLT proceedings, which was moved. And then kindly come to para 24. Applicants petitioners have sought the following reliefs to cause necessary interim direction to AP Genco not to proceed with any coercive measure before any of the forum in respect of the alleged claim to be paid by Telangana Discom, that is a petitioner, until the main petition is disposed of by the commission. And under the Electricity Act, any dispute between a generation company and Discom, the Electricity Regulatory Commission has the jurisdiction. Respondents have not filed any counter affidavit either in the original petition or this interlocutory application. I have heard the counsel for the petition and perused the material on record. Though the counsel for the respondent did cause appearance on their behalf, yet did not make any submissions in this matter. In this regard, record of proceedings as recorded by the commission is reproduced. The time was taken for counter, but nothing was filed. Those are all recorded, proceedings are recorded. Then para 27, even on the last date of hearing, that is on 112, no counter affidavit is filed, but time is sought for filing counter affidavit. Have to trace out the record pertaining to long old period, and for that they need sufficient time. Prima facie, on the basis of the above position as obtained in the matter, question that arises for consideration is whether there is a balance of convenience in favor of applicants for interim order, and if so, to what extent. Commission is empowered to pass such orders as may be appropriate under Section 94(2) of the Act of 2003. In this case, applicants are seeking interim direction not to take coercive action by respondent number 1 in proceeding with any litigation before any forum till this commission decides the dispute raised by them under Section 83. This commission is of the view that prima facie a dispute between a generator and should be a generator and a Discom is amenable to its jurisdiction as provided in Act 2003 and as upheld by judgments of courts of law. Moreover, applicants of the licensees of this commission are required to undertake power supply in the state of Telangana. Any hindrance to discharge of this function of the applicants would not be in the interest of the public at large. Therefore, the balance of convenience lies in favor of the applicant. Commission is also of the the actions of the respondents, more particularly respondent number 1, if allowed to be proceeded with, may not only cause severe damage to the interests of the applicant, but also are contrary to law and provisions of the statute. No prejudice will be caused to respondents if the actions of respondents are stopped pending disposal of the petition. As such, actions can be proceeded with after disposal of this petition. Moreover, respondents have not chosen to state their case by filing a proper counter affidavit as to why interim relief shall not be given to the applicant. In these circumstances, and for the reasons recorded therein, exercising the power conferred on the Commission under Section 94(2), respondents, more particularly respondent number 1, is restrained from any coercive action before any forum till this Commission decides the original petition, the larger public interest in progress. And it is in regard to the very same use up till October 2017. This order was challenged by the AP Genco. The response here, my lords may see in the petition, Andhra Pradesh Power Generation Corporation, which has supplied the power, and the petitioners are the Discoms, Telangana Discoms. And though this was challenged, no interim order was passed by this honorable court or after transfer by the Andhra Pradesh High Court. And the matter is still pending. And the OP 59 of 2018 is also still pending. So the very subject matter of the dispute in regard to the dues in respect of power supplied by Genco is the subject matter of our competent proceedings before the Electricity Regulatory Commission, which has not yet been disposed of, and there is an interim order. And this is not even taken note of by the Government of India. I'll place the relevant proceeding. Now, I have already placed the order that doesn't take note of this. Now, if I come back to the list of dates, this is again interesting. Very, 19th August 2019, Telangana and Andhra Pradesh Power Utilities signed a reconciliation statement for all power utilities of both states that all power utilities issues will be settled at state level. AP Genco has been insisting on settling merely power purchase dues while completely ignoring other power utilities due to state of Telangana, such as debt servicing, etc. Now, this is also very relevant. May I place straight away, if my lords will kindly have a look at page 170 of the paperwork, a writ petition. Minutes of the meeting. Dated 19th August 2019. Unmilled AP Energy Secretary is there, Chairman AP Genco, Chairman AP Transco, all of them are there. Similarly, Telangana side, Special Chief Secretary, Government of Telangana, CMD, the Genco, etc. are there. Kindly now see, Millard, what is all the disputed issues between the power utilities of both the states were discussed and the decisions taken are indicated in the annexure. And kindly now see the annexure. Annexure to, I'm sorry, Millard, it is in the reverse. Annexure to the minutes of meeting dated 19th August 2019, issues between AP and Telangana state power sectors. Power bills, decision taken, both agreed. Unmilled amount due by AP 8,199 crore, by Telangana state 11,641 crore. Interest on sales of power due to AP Genco agreed to pay on net amount yet to be resolved 604.7 crore. Demerger adjustment account on account of mismatch of assets and liabilities issued to be referred to C&AGs for opinion. Amount is indicated. Interest overdue on FRP discount bonds after employee bifurcation. Like that, some of these items are deferred. Some agreed upon interstate sales, reactive charge claims, energy charges, various things. And as what is agreed in this meeting is 10,160 crore is due by Andhra Pradesh, 12,648.76 crore is due from Telangana utilities, and this yet to be resolved 4,609 crore, of which the main thing is in regard to employee bifurcation. As my lords may see, the items are 1180 crores investment of pension trust and 125 crore, 150.
Where, which employees, which entry?
Yes, well, it is in the last column yet to be resolved. The items are kindly similar from 4 to 6, 7, 8. These are yet to be resolved. And these amounts now the employee bifurcation has been done, completed. Therefore, this was to be done after employee bifurcation. That is also completed. Therefore, these amounts also will have a substantial part is due to Telangana. We have given a subsequent comparison as to how much money is due. About 20,000 crore is due from Andhra Pradesh, which we have indicated. These amounts still pending. This was what was agreed upon in 2019. And today, both sides want. In fact, when the petition filed by Andhra Pradesh, which was for distribution of assets and liabilities division, a consolidated petition, the Government of India had appeared through the learned additional Solicitor General, Ms. Aishwarya Pati had appeared, I think, at that stage. They had not filed the counter affidavit. So one of the suggestions that was said was, why not try to resolve? Because Government of India Ministry should resolve. If they are not able to do, send it for mediation to some retired Supreme Court judge was one of the suggestions which Government of India said will consider. So the matter stands posted to November. Now, this writ petition is filed by them 10 days before the order is issued by the Government of India. What compulsions were there? There are various things that take place on the floor of the Parliament and elsewhere, to which we can't take note of, and I don't want to draw reference to that. But whatever it is, some compulsions because of which this order came to be issued. Though substantial amounts, which I will, when I deal with come to the relevant date, I will point out. Now, to come back to the list of date.
So where is that order? You said that between the two state governments, there is an order saying that it should be referred to a former Supreme.
What has that's not been recorded in so many words.
Okay.
Yes. Now, please see. Please have a look at the. Yes. Look at the petition copy and the order. Last time. Yes. Order dated 4th August 2023. In fact, the SG was to appear. SG could not be present, but Mr. Natarajan had appeared. Yes. You got the copy. It's 4th August. Kindly have it. Kindly give to the government. One more copy. 25th copy. This was on 4th August. Reply has been filed on behalf of respondent number 2, State of Telangana. Learned Counsel for respondent number 1, Union of India, prays for and is granted 3 weeks time from today to file counter reply. Rejoined affidavit, if any, may be filed within 3 weeks after service of counter affidavit reply. Relist in the month of November 2023. And the suggestion came, one of the prayers in the petition itself is for a reference of the disputes to arbitration or mediation. That was that prayer. We have copied this petition. Last time we had taken. Yes, please. That's all. Kindly have a look at the prayers, Miller. Para 10. Non-apportionment of assets has led to multitude of issues adversely affecting and violating the fundamental and other constitutional rights of people of state of Andhra Pradesh, including employees of the said institution. Without adequate funding and actual division of assets in terms of apportionment made under the Act, functioning of the said institution, state of Andhra Pradesh, has been severely stunted. Post bifurcation, Hyderabad was the capital, not only transformed into an economic powerhouse, etc., etc. Then, please come to next page. Approximate value of assets of headquarters of Schedule 9 institution is estimated at 24,000 crore. In respect of Schedule 10 institution, total approximate value of fixed assets to be divided between two successive 34,000. All this on the basis of real estate value. Whereas Act says, headquarters will be given to respective where it falls, and there will not be distribution and valuation on this basis. Whatever it is. Now, what is important is kindly see, it refers to various committees which have gone into this. Sheila Bide Committee, Para 22, Para 24, Dispute Resolution Committee, with the Union Home Secretary as the chairman of field secretaries of both the state. and as chairman and chief secretary of both states as members. This committee has held several meetings, including meetings held on so and so. All those dates are mentioned. And Millard, reference under section 66. Then the disputes which are pending, para 28 Andhra Pradesh Bhavan. Then para 38. Millard, reference made to another petition pending. Then AP State Council of Higher Education, where Supreme Court Justice Gopal Gowda had disposed of the matter and sharing how it is to be done. Telugu Academy, Dairy Development Cooperative Federation, Mineral Development Corporation, then request for arbitrations, and then the grounds, and then kindly now come to asset, the page 29, what are to be shared, page 28 bottom, in terms of the assets, 4 distinct categories: assets movable and immovable belonging to the state, assets movable and immovable belonging to organizations, corporations mentioned in Schedule 9, and the GENCO and TRANSCO are entities mentioned in Schedule 9. Organizations, corporations mentioned in Schedule 9. Both GENCO and TRANSCO are mentioned in Schedule 9. Assets movable and immovable belong to organizations mentioned in Schedule 10. Assets movable and immovable belong to organizations not mentioned either in Schedule 9 or Schedule 10. Assets belonging to the state, those are set out, Millard. Then the institutions. And then the prayer at page 37. Prayer. Declaring, page 38, declaring the inaction of the state of Telangana and Union of India in not dividing the assets and liabilities of erstwhile state of Andhra Pradesh, including assets and liabilities of institutions specified in Schedule 9 and Schedule 10, as also other institutions between two successive.
Para 539.
Yes,
Appointed.
yes, that's right. Appointed impartial, neutral, and independent arbitrator of the to supervise and monitor the actual division of assets and liabilities. In fact, some such names were also suggested at that time, at some stage.
All right. So,
This is
what are your submissions, Mr. Broadly, if we can note down?
Yes.
Submissions.
My, if I have a note where in 2 pages I have crystallized, that will be easier, if I may give that note. My copy. No. Yeah. Yeah. A 2-page overview.
This thing.
I have a copy.
We only reference to this. Schedule 9. Schedule 9. If we say that there were disputes and Schedule 9. And the two other issues. The issue of power sharing is not there in the application price.
I have to complete the list of dates, but
yes.
I will first break the give a broad overview and then go to the list.
You can complete the list of dates
Yes.
then.
I'm grateful. I'm grateful. When I was on
19th August.
That's right. 19th August 2019, I had shown that 2021, Andhra Pradesh Power Utilities filed writ petition 21638 of 2021 before this Honorable High Court against State of Telangana for payment of post-bifurcation dues. This is the same amount in regard to supply. Then, in regard to the very same dues for supply of power, they filed a writ petition. This was withdrawn on 9 June 2022. They filed NCLT petition in NCLT, withdrawn. They filed a petition, writ petition in this honorable court, withdrawn. We had got an interim order restraining them. They have filed a writ petition challenging that. That is still pending. There is no stay. Now, then 2021-22, Andhra Pradesh requested Ministry of Power, Ministry of Home Affairs, Government of India for intervention to get their power purchase used. Now, though they have been restrained from moving any, they say that we will now move the Government of India. During various meetings, State of Telangana represented that all bifurcation related issues to be taken up together rather than only power purchase use as requested by Andhra Pradesh. Letters from State of Telangana to Government of India regarding pending dues payable by State of Telangana from State of Andhra Pradesh. Breakup of total receivable by State of Telangana payable by AP Power Utilities to Telangana State Power Utilities, showing Telangana has to receive 12,940 crores from Andhra Pradesh after directing money that has to be paid to AP Genco for power purchase by Telangana State Power. Now, if they file a civil suit or any other claim, I will be entitled to get a set of the Telangana Power Utilities, and if I set it off, after deducting all that, they owe me 12,940 crores. This is not taken into account by the Government of India, and I will show from the notes which have been made available that somebody records in the noting file that State of Telangana has not produced proof in regard to these documents, in regard to these claims. Extraordinary. But did you even give me an opportunity for all this? With great respect, the way they have gone about it's something which is shocking. Telangana Genco filed writ petition.
So you are not this thing put on notice before this?
No, please see, that's why I want to take my lords through the list of dates. Because they said we will take it up in the committee in September. 3rd September. The order is issued on 29th August without even hearing me. When I was put on notice that this is a matter which will be taken up by the committee on 3rd September. Well, please now see. Therefore, we had to, since our monies were not being paid, we filed petitions which are all pending, and they have not been listed today. In fact, I had made the request that they should be taken up together. Of course, my learned friend appearing for the AP Genco opposes that. Please see, these are pending. But Genco, Telangana Genco filed petition 25240 to pay bifurcation dues amounting to 4,774 crores to State of Telangana. This petition is pending and it's subject. Telangana State Power Distribution Company filed a petition 25788 to pay post-bifurcation dues amounting to 11,324 crores to State of Telangana. This petition is pending. All these are pending in this honorable court. TS Transco filed a petition 34824 of 2022 to pay employees' trust funds and other dues to State of Telangana. This petition is pending and is sub judice. And in none of these, counter affidavits have been filed. There is no answer. These amounts are due, but nothing is there. They don't want to final counter of it or have the matter taken. Now, I will take my lots through the file notings in regard to what takes place, but I will, I have referred to it. Now, please see 8/2/22, Office Memorandum and Meeting Notes to the Government of India, Ministry of Home Affairs, providing that meeting will be conducted practically resolving issues arising from Andhra Pradesh reorganization act. Meeting of Dispute Resolution Subcommittee scheduled for 17 February 2022. Then the Ministry of Law and Justice seeks opinion. Their opinion is sought. It was replied that the matter is sub judice, governed by bilateral agreement, and Government of India recommends amicable solution. It was also noted that State of Telangana has claimed amounts for post-bifurcation dues. AP Genco has already filed a case before Telangana High Court. Matter is referred to Solicitor General. Solicitor General says when the matter is pending in the High Court, no directions can be given. That is on 12th March 2022. Since the matter is sub judice, it's not appropriate for central government to issue direction. 15th March opinion given by so-and-so. Then 28th May, I shall be placing these meetings minutes, which are important. 12th Standing Committee of Southern Zonal Council, committee decided to keep the item of post-bifurcation power utilities dues for discussion in 30th South Zonal Council meeting, which was to be held on 3rd September 2022. This is a very important document. Kindly have a look at that. Page 158. Page 158 of the petition. Right. Kindly similar how they have been discussing various items and resolving. Items discussed in the 12th Standing Committee of Southern Zonal Council held on 28th May 2022 at Thiruvananthapuram. In the 29th Southern Zonal Council meeting held on 14/11/2021 at Tirupati under the chairmanship of Honorable Home Minister Shri Amit Shah, discussions were taken up on 45 items, out of which 19 were resolved, and 26 items have been carried forward for discussion in the Standing Committee. Further, 63 fresh items have been listed for inclusion in the agenda for the 30th South Zone Standing Committee meeting. The carried forward items were categorized under Part 1 and fresh items under Part 2 for discussion in the 12th Standing Committee of Southern Zonal Council. Out of the 26 old carried forward items, 10 related to Government of Telangana and action to taken reports were submitted to Standing Committee, and item-wise deliberations were held on 28th May 2022 in the Standing Committee and are noted under Part 1, Agenda Item 8. Dues of 6,015 crores to be paid by power utilities of Telangana to Andhra Pradesh towards the cost of power supplied by Andhra Pradesh after the state bifurcation. Very same issue. Government of Telangana informed the committee that there are many demerger related issues between AP and Telangana power utilities which have to be settled. And once all these issues are settled, the post-merger of AP Genco dues will also be squared up. In fact, Telangana power utilities have to get around rupees 17,828 crores from AP power utilities. And after setting up the dues payable to AP power utilities, Telangana Genco has to get 12,940 crores. Government of Telangana has also brought to the notice of the committee about the transfer of share of Telangana amounting to rupees 2,884 crore in the employees trust funds, pension, gratuity, EL encashment, DF and gratuity still being maintained by AP Genco and AP Transco. They have the money, they have to give us. The committee was further informed about the discussions on the issue before the dispute resolution subcommittee meeting held on 17th February 2022, wherein the joint secretary suggested that after getting the views of Ministry of Law, Ministry of Power may communicate the same to both governments and Ministry of Home Affairs for the comment. Action will be taken on the issue based on the comment of both the state government and the opinion of Ministry of Power thereof. And this opportunity was not given. As per the opinion of Ministry of Law and Justice, the Department of Legal Affairs, Government of India, Section 92 confers on Government of India unambiguous powers to issue directions to the State of Government of Telangana for payment to State of Andhra Pradesh. This, in my respectful submission, is an incorrect understanding. Since the matter is sub judice before the court of law, it would not be appropriate for Government of India to issue such direction under Section 92. Energy Secretary, Government of Andhra Pradesh, in letter dated 19th May 2022, addressed the Ministry of Power that AP Genco has decided to withdraw writ petition 21-638 and requested to issue direction. But there are other petitions filed by us which are pending. They may withdraw the writ petition, but our writ petitions claiming money from them is still pending. Committee has decided to keep the item for discussion in 30th South Zonal Committee meeting during August 2022, which actually when it takes place on 3rd September, that notice is given. Yes. 64. Kindly similar page 164. From the Secretary, Interstate Council Secretariat, Ministry of Home Affairs, Government of India, dated 4th August 2022. The approved address to the Chief Secretary, Government of Telangana, the approved minutes of the 12th meeting of the Standing Committee of the Southern Zonal Council held on 28 May 2022 at Tirunelveli have been forwarded by the Secretariat on 3rd August. As you are aware, the 30th meeting of South Zone Committee is scheduled to be held at Tirunelveli on 3rd September 2022. In this regard, I would like to mention that the retained issues from the 12th meeting of Standing Committee on 28 May 2022 would be included in the agenda of the forthcoming 30th meeting of South Zonal Committee. It is requested that the updated position of such issues may kindly be sent to the Secretariat at the earliest and in any case latest by 18th August, so as to enable the Secretariat to finalize the agenda. And this is one of the items which had been kept back, being taken up in the 30th meeting. In this context, I would like to mention several of the issues were treated as solved or dropped, etc. And then kindly see the items, pending items, page 165. Agenda item number 8, page 165. Dues of item 8, say agenda item 8. Dues of rupees 6,015 crores to be paid by power utilities of Telangana to Andhra Pradesh towards the cost of power supplied by AP after state bifurcation, sponsored by Government of Andhra Pradesh. That is there, this one. And the details are set out at page 166. Dues of rupees 6,015 crores to be paid by power utilities of Telangana to AP towards cost of power supplied by AP after state bifurcation. Secretary ISCS informed that the issues is regarding so-and-so, and at the end of that paragraph, in the 29th meeting, it was decided that Union Home Secretary will call a meeting to resolve the issue. Nothing was done. Union Home Secretary did not call a meeting. It was not taken up in the Southern Zonal Council meeting of 30th, but even without all this, an order is issued. It was also brought to the notice in the meeting that a committee constituted by Ministry of Home Affairs on dispute resolution had discussed the matter with representatives of Government of Andhra Pradesh and Telangana. On the recommendations of the committee, Matter was referred to Law Ministry by the Ministry of Power, and Law Ministry has conveyed its opinion to Ministry of Power, according to which, since the matter is subject before court of law, and during pendency of dispute between Andhra Pradesh and Telangana in Telangana High Court, it will not be appropriate for the Government of India to issue any direction. It is also mentioned that Government of AP has informed that AP Genco has decided to withdraw the writ petition from High Court, and they requested Government of India to issue direction in the matter. Representative of Government of Andhra Pradesh intimated that the Energy Secretary of the state has already sent letter informing the updated status to Ministry of Power. Representative of Ministry of Power stated that the ministry will take appropriate action once the letter of withdrawal of case by Government of AP is received. In this context, Special Chief Secretary Government of Telangana requested that they should also be heard in the matter, and the Energy Secretary of the state had sent communication regarding this. That is, they have, AP says they have withdrawn, then we say no, but we should be heard before you take any decision. Standing committee, then what the standing committee decided, treated the item as pending with the advice that AP will share the letter with the Ministry of Power, and also the Telangana's views to be heard at the time when the Government of India gives direction in this matter. Standing committee headed by the Honorable Minister, Mr. Shah, takes a decision that Telangana's views will be heard at the time when Government of India gives direction in the matter. We were not heard. No such hearing took place. Neither the secretary nor the committee heard Telangana and have unilaterally issued this order. Therefore, this is one of our principal grievances. We should have been heard. Now, Millard, if I come back to the list of dates. (9/6) order of this honorable court allowing the petition to be withdrawn. And Millard, there is one more petition ordered by so-and-so against AP Genco for payment of dues by AP to Telangana. Notice issued by this honorable court. Then meeting of dispute resolution committee. Then 1722 meeting notice, Ministry of Home Affairs, which I have already read. File noting. Now, Millard, I will take my lords now through the file notice before I make submissions on this. Then, Millard, kindly come to the next page. 19th August, writ petition 1091 of 2022, filed before the Honorable Supreme Court of India by State of Andhra Pradesh against Union of India and State of Telangana for payment of post-bifurcation dues, which I have already placed. 19th, same date, 19th August, letter from Deputy Secretary Energy Telangana to Chairman MD to transport to furnish latest update on the issue for 30th Southern Zonal Committee, which we give. Then on 9th, same day, a further opinion which had been sought from the learned solicitor is provided that despite there being no stay, any lawful action will be subject to final outcome of legal proceedings as well as subject to challenge by the aggrieved party. I'll place the Solicitor General's opinion. Since now the writ petition has been withdrawn, an order might be issued, that of course will be subject to final orders of the court. File noting by ministry, taking note of the further clarificatory opinion. Then 26th August, after this opinion is received on 24th August by the ministry, file noting by section officer, Ministry of Power, providing a draft order on the basis of which there is no legal impediment on Union of India to do so. 29th August, impugned order is issued. Not taking note of the fact that a meeting is to be held on 3rd September. It had been to take in the consultative committee meeting presided over by, chaired by the Minister for Home Affairs. A decision had been taken that State of Telangana will be heard before any decision is taken. None of this is brought to the notice. Minister of Power says, yes, this order may issue, and the Ministry of Power has issued the order. Ministry of Home Affairs is not kept in the picture at all in regard to this, though Ministry of Home Affairs has taken a decision, we'll be heard. Then, Millard, we have made representation, we filed petitions, etc. Now, Millard, I'll give the broad overview of my submissions and thereafter I'll take my lords to the noting file also, which has been, a copy of which has been given to me. First minute, page, broad overview of the submission has been given. I will not go into the detailed submission, but I will first give the broad overview. There were 31 power purchase agreements executed between AP Genco and AP Transco. These PPAs had been executed also. Section 92, all those not returning above, sought to disturb the supply. Present dispute, para 4. Present dispute is in respect of non-payment of certain amounts alleged to be due by AP Genco from Telangana Discom in respect of such supply of power during this period. Now, para 5 is important. Commercial arrangement of supply of power and payment, therefore, is governed by the PPAs, and AP Reorganization Act 2014 had only directed that the PPAs will continue to operate as between the parties. PPAs govern the procedure for mechanism of raising bills, payment of amounts, and in case of disputes, how it is to be settled by negotiation between chief executive, failing which by arbitration, and in the events of disputes and differences by requesting the State Regulatory Commission to settle such disputes. The AP Genco has not chosen to adopt any of the procedures contemplated by the PPA, nor have they invoked the powers of the State Regulatory Commission for settling the disputes or differences, for making the payment, or for directing State Telangana Discom to make the payment for power supply. Nor have they filed a civil suit. On the other hand, we filed a dispute before the commission. That's para 6. Telangana Discom filed OP 59 of 2018 before TSHC, which has restrained AP Genco from taking any coercive action. The risk proceeding challenges said order is still pending. There is no stay. They chose to file another writ petition, which they have subsequently withdrawn. They made a representation to the Government of India, who have now sought to exercise power under Section 92 to direct the successor state of Telangana to make payment. Neither of these entities, namely the state of Telangana nor state of Andhra Pradesh, where parties are privy to the PPA. Neither of them, the states are not parties. It is between Genco and Discom. And Section 92 of the AP Reorganization Act 2014 has no application whatsoever in this given case. State of Andhra Pradesh has filed another petition 1091 of 2022 before the Honorable Supreme Court for resolving issues pertaining to post-trifurcation. In the narration of facts in the impugned order, Government of India has rightly noted that the dues related to supply of power by AP Genco to Telangana Discom. How a direction can then be issued to state of Telangana to make payment to state of Andhra Pradesh, and how Section 92 is applicable is not set out. Notes of the ministry during the relevant period also disclose that there is absolute lack of application of mind to any of these aspects. Central government is not constituted as the dispute settling authority in respect of such dues. Section 92 does not confer any such adjudicatory power. Without prejudice to the aforesaid, even if such adjudicatory power is there, the dues from state of Andhra Pradesh, AP Gencos, AP Discoms to state of Telangana, Telangana Gencos and Telangana Discoms, these have also been noted in the noting files, but the Government of India proceeds on the basis that the claims of Telangana have not been substantiated by any document, which is completely incorrect. In any case, an opportunity should have been given to state of Telangana, and state of Telangana should have been heard before any such direction was issued to state of Telangana to make such payment. This is without prejudice to the submission that state of Telangana cannot be directed to make any such payment by the central government, because in respect to what is due from discounts to Genco, state cannot be made responsible. Dispute resolution in such matters, more particularly between the state and states companies, have to go through an independent adjudication machinery, particularly after the separation of executive and judicial function. Central government cannot usurp such functions. Judiciary was approached by way of a petition, but the same having been withdrawn, there cannot be unilateral adjudication and that too without hearing the affected parties by the central government. Independence of judiciary for the purpose of dispute resolution is one of the basic structures of the constitution and could not have been and have not been taken away by the provisions of AP reorganization. This broadly would be some of the submissions that I will be making. Now, I will place the relevant provisions of the Act and then I will place the noting point, which is important because that shows how they have approached. Kindly have a look at AP Reorganization Act. That broadly, the statute is arranged in a manner where what happens to the states, division, areas, then legislature, all these are set out in part 2, reorganization, representation, part 3. Then part 4 is in regard to High Court. Part 5 is authorization of expenditure. Part 6 is apportionment of assets and liabilities. Part 7 is in regard to the corporations, specific provisions made. Part 8 is in regard to services. Part 9 is in regard to management of water resources. Part 10 is what is relevant for us, infrastructure and special economic measures. Section 92. Section 92. Successor states to follow principles, guidelines, etc. issued by central government. This is the power that they are seeking to invoke. The principles, guidelines, directions, and orders issued by the central government on and from the appointed day on matters relating to coal, oil, and natural gas, and power generation, transmission, and distribution as enumerated in the 12th schedule shall be implemented by the successor states. Now, therefore, this is the power that they are seeking. This doesn't confer any adjudicatory power. This doesn't confer any judicial power. It talks of principles, guidelines, directions, and orders issued by central government on matters relating to coal, oil, natural gas, as enumerated in the 12th schedule, shall be implemented by successor states. Now, let's kindly come to the 12th schedule. Which is referred to in section 92. Let A is coal, B is oil and gas, then C is power. Units of AP Genco shall be divided based on geographical location of power plants. Existing power purchase agreements with respective DISCOM shall continue for both ongoing projects and projects under construction. Existing Andhra Pradesh Electricity Regulatory Commission shall function as joint regulatory body for a period not exceeding 6 months, within which time separate SCRCs will be formed in the successor state. Existing state load dispatch center shall function for both successor states for a period not exceeding is within which time separate SLDC shall be set up for each successor state. During this period, existing SLDC shall function under the direct administration control of Southern RLDC at Bangalore. Transmission lines of AP Transco and high voltage cutting across successor states shall be deemed as interstate transmission system line. Transmission lines falling within the territory of each successive state shall be transferred to the respective state transmission utilities. Maintenance of ISTS line shall also be done by successor state in the respective jurisdiction. Power of central the generating stations will be allotted on such ratio to state of Telangana and state of Andhra Pradesh based on the actual energy consumption of the last 5 years. For a period of 10 years, successor state that has a deficit shall have the first right of refusal for the purchase of surplus powers from other states. Districts of Anantapur and Kurnool will fall within the jurisdiction of AP Central Power Distribution Company, will now be reassigned to AP South Company. Therefore, 12th schedule says existing power purchase agreements will continue. They could not have unilaterally sought to terminate the PPA, which is in the teeth of the express provisions of the statute. It is a clear violation of the statutory provision, which has been restrained by the AP Regulatory Commission in the August 2014 order. They sought to take law into their own hands and terminate contrary to the provisions of the Act. They sought to stop supply of power, which also, the state load dispatch center said, you can't do that, you will have to supply power. Now, that direction of POSOCO is treated as a direction by central government, and central government says, we had directed supply of power, and therefore, we are using this power under section 92 to direct you to make the payment. Well, that is what is contemplated by the Act. They don't have to. They merely made a reference to the provisions of the Act which directed continuance of the PPA. Therefore, they are bound to supply power. And once they say PPA, once the statute says parliamentary wisdom says PPA will continue, all the provisions of PPA including in regard to payment, dispute resolution, etc., all these will continue. There is no exclusion. And we have invoked the power of the State Regulatory Commission, which has granted an order restraining them. They challenged it, no stay has been granted, and they have not sought to take, they invoked the powers of NCLT, they didn't move the Regulatory Commission. They invoked NCLT, withdrew. They moved a writ petition, withdrew. We have filed a writ petition challenging. Now, this is the status. Section 92 does not confer any power. Now, please have a look at the notes file, which is very important, how the whole matter has been dealt with by the Ministry of Power, without taking note of what is taking place simultaneously under the Ministry of Home Affairs in regard to all these disputes. And the Ministry of Home Affairs files have not been produced. Ministry of Power, because this is relating to the order which has been issued, impugned order. Kindly have a look at the notes file.
Where is it?
I think the original file is
Original file.
My lord, sir. The notes. Yes. Now, kindly see. Now, interestingly, when there is a consultative committee meeting and various other meetings are taking place, which is not noted here, please come to para 2. Honorable Chief Minister of Andhra Pradesh sent a due letter of the first note, page 1.
Which are like background something.
Yes, that's right. My lord, sir. Yes, background. That's it. I'm great. Background. My lords referred to background. That's the one that I'm referring to. Page 1. Background. Subject is non-payment of dues of rupees 6,111.88 crores by government of Telangana discount to Andhra Pradesh. Consequent upon implementation of Andhra Pradesh so two counter states are their independent entities. And they're having certain unresolved issues amongst them. Honorable Chief Minister of Andhra Pradesh sent a DO letter dated 14/7/2021. I believe, Millard, it has been corrected. That's a copy given to me has a correction, not 2014 typed out, but a correction is there 2020. Yeah, 2020. So this is the whole process starts with this letter. What has happened? The simultaneously meetings are going on, some agreements are arrived at. Nothing of this is noted. A letter goes from Chief Minister of Andhra Pradesh to the Honorable Minister for Power regarding non-payment of power dues by Government of Telangana for supply of power by AP Genco to Telangana Discoms post bifurcation from 10/6/2014 up to 10/6/2017 as power deficit faced by Government of Telangana during the period. They are bound under the law to continue to supply power under the PPA, and it is as if they have obliged us in supplying power to meet our power deficit. Look at the way it is projected. It has also been requested to direct it from the union devolution of Government of Telangana to settle the dues. Extraordinary. Therefore, whatever ministry has to, Government of India has to give state of Telangana from TSP or grant, everything. Now, from out of that, this will have to be directed. In order to solve the matter, Secretary Power chaired a meeting with representatives of Government of Andhra Pradesh and Government of Telangana on 8/11/2021. Minutes are at Black Sea. Provisions of Andhra Pradesh reorganization are dealing with apportionment of assets are as under 47(1)53 assets and liabilities of state undertaking. Section 66 power of central government to order allocation of adjustment in certain cases. These are not the powers invoked here. Section 12 under Schedule 12 under Section 92 that is set out. Section 92 is set out. Para 4, page 3 bottom. Honorable CM of Andhra Pradesh, Vijay's letter dated 14/7/2021, has informed that AP Gencos had supplied power to Telangana Discoms post bifurcation from 2/6/2014 to 10/6/2017, which appears to be under existing PPA cited in Clause C2 of Schedule 12 of AP Reorganization Act. So this is not an issue in respect of apportionment of assets and liability of the existing state of Andhra Pradesh immediately before that point. If it is not apportionment of assets and liability, it is a dispute arising under PPA, for which there is a forum created by the Parliament in its wisdom under the Electricity Act, which I have invoked, which has passed an order in my favor, not vacated. If it is not in regard to apportionment, then it comes only under that. How do you exercise the executive power purporting to be under Section 92, adjudicating disputes, and then Millard asking me to pay? Post bifurcation, Telangana had been paying for the power they had been purchasing from Andhra Pradesh. Subsequently, they are not paid against power purchase. During the meeting taken by Secretary, Telangana confirmed that they don't have any dispute with regard to principal amount. However, only some reconciliation is required with respect to interest payment. Due to hence is the matter which is post bifurcation, the matter is to be settled among themselves under the terms of PPA. Has to be settled among themselves under the terms and conditions of PPA. Meanwhile, it also emerged during the meeting taken by Secretary Power that Andhra Pradesh has already approached the High Court of Telangana. Telangana also informed that they will be filing the reply. Hence, the matter is also subjudice. As per Clause C2 of Schedule 12, existing PPA continued with respect to Discom. However, from the date of bifurcation, The agreement between Andhra Pradesh and Telangana power was supplied to Andhra Pradesh to Telangana. It has also been established that the meeting chaired by Secretary Power with the representative that the power was supplied by AP Genco as per agreement between bifurcated states from the date of demerge, which is a post-bifurcation. Initially, Telangana was paying. There is no dispute to the principal amount. So reconciliation in regard to interest, for which both representatives had agreed to reconcile the figure. It would be pertinent that the expenditure of power during post so and so was incurred by government of India. Therefore, it makes Andhra Pradesh liable for the rightful. In part file on this subject, Ministry of Power has made the Honorable Minister for Power has made the following observation. Every right of one party entails corresponding duty on another. Right and duty are conjoined. This is extracted verbatim in the order. Right of one to review power under PTA or having the first refusal of power to power supply entails a corresponding duty to pay for power. If so, we can give a direction to Telangana to pay for power under that. Please have this examined in consultation in shape. This is what Minister for Power had already written in the letter. Other issue will be that if we give an order to pay, how shall we enforce it? Can we have this amount deducted from the account of Telangana and credited to AP? Is there any penalty per account? In order to get the issue resolved and the outstanding due settled by so-and-so, draft communication to Government of Telangana is proposed at DFA. Then it goes through various files. I'll not trouble my lords with all this one, but kindly come to the noting of the Under Secretary of 31st January at page 10. It starts at page 7, where the previous things are noted. And para 9, the issue was discussed on 25/1/2022 in the committee under the chairmanship of Secretary, involving Secretary, Ministry of Water Resources.
Page, para
Page
9.
10, para 9. My lords have that.
Yes.
Yes. Para 9. This issue was discussed on 25th January in the committee under the chairmanship of Secretary, Ministry of Finance, involving Secretary, Ministry of Water Resources, Additional Secretary, PMO, Joint Secretaries of other ministries from Government of India. From the Andhra Pradesh side, delegation was led by the minister along with other officers. Now, nobody from Telangana. This meeting is held with all these officers with the state of Andhra Pradesh. Telangana is not told. Nobody, no representative from state of Telangana. This meeting of 25th January. During the meeting of the committee, decided. During the meeting, the committee decided that under Section 92, Government of India can issue order for payment by Telangana to Andhra Pradesh. It was also decided by the committee to examine whether it can be covered under the tripartite agreement with Reserve Bank of India, as the case of NTPC and other CPSUs. Decision of the committee is also aligned to the direction of the Honorable Minister of Power as indicated in para 8 above. Government of Andhra Pradesh, YD letter dated 27/1, has conveyed that there are no interim court direction in the case filed by AP Genco in Telangana High Court against State Telangana DISCOMs pressing for payment of power dues. Case does not come in the that there is an order of the State Regulatory Commission restraining them from taking any coercive step is not brought to the notice of the Government of India by the Government of Andhra Pradesh. And that order is not straight. They have once again requested Government of India to issue necessary direction to Telangana State Discom under Section 92 to release for release of power supply dues to AP Genco towards supply of power made to Telangana. Thus, it is being proposed to issue order in terms of Section 92 of AP Reorganization Act for payment of dues. In the event of non-payment, even after the proposed order, the matter will be referred to Ministry of Finance for directly deducting Telangana's account and paid to Andhra Pradesh. Accordingly, draft order is proposed asking the government of Telangana to make payment. Advice of so-and-so is solicited on the questions raised. Then, Miller, it goes to the Ministry of Law. Now, Miller, please see para 2. Ministry of Law, as mentioned in para 1, Honorable Chief Minister of Andhra Pradesh has sent a DO letter to Honorable Prime Minister regarding non-payment of power dues by Government of Telangana for supply of power by AP Genco. For post bifurcation as power deficit faced by Government of Telangana, it has also been requested in the DO letter to be directed from Union Revenue. In order to resolve the matter, Secretary Power chaired a meeting with representatives of Government of Telangana, Andhra Pradesh and Telangana on 8/11. As regarding the minutes following the so-and-so, there is no dispute. Agreed to reconsider the figure has not been received. Filed the petition. Telangana. Now let's see. Telangana has claimed certain amounts to be paid by Andhra Pradesh on account of issues related to outcome of demerger of 3 power utilities affected by bifurcation. Telangana representative is committed to pay the net amount, if any, after incorporating demerger related dues and remaining dues for power supplied by AP Genco. Sheila Vijay committee has dealt with all the demerger issues and given the recommendation. However, both Andhra Pradesh and Telangana have not issued the order as per recommendation so far. As the matter relating to payment of duties pending in the High Court, it was suggested both Andhra and Telangana should once again discuss pending issues and send the status note to the Ministry of Power. Observations of the Honorable Minister of Power, etc. Then those are set out. Kindly now come to Miller, page 15, para 11. On perusal of papers made available in file, it appears that in the written reply to Lok Sabha short question number 72, answered on 2/12, relating statement was made by the Ministry of Power that as a matter is sub judice and the power was supplied under a bilateral agreement. Government of India has suggested to both the states to amicably resolve the issues among them. Again, the Honorable Minister of Power in his communication dated 11/1 to so-and-so in respect of issue raised by Honorable MP has also stated as a matter of sub judice and the power was supplied under bilateral the agreement. Government of India has suggested both the states to amicably resolve the issues among them. It seems that there is no dispute of the principal amount to be paid for power supply to Telangana. However, some reconciliation is required in the interest has to be considered. Telangana has also claimed certain amounts to be paid by Andhra Pradesh for which is related to outcome of demerger. AP by Genco has already filed a case before Telangana. Details and copy of case, if any, filed by Telangana, are not available in the file. Now, we have filed the cases and they have notice has been issued to them, should have been made available. Now, that's not noted. Now, kindly thereafter, legal opinion is given by the Solicitor General. Kindly come to page 20. Para 3. Sorry. The learned solicitor opines that Section 92 empowers the Union of India, enables central government to issue principal guidelines, directions, or orders, and it can issue an order for payment of dues. According to me, this opinion, in my respectful submission, it will not be binding on my lords, and in my respectful submission, Section 92 does not confer any such power. Then B, with regard to query B, I am of opinion that since the parties to dispute have already chosen the remedy by invoking jurisdiction of the Honorable High Court of Telangana, by filing appropriate petition for remediating its grievances on merit, therefore it would neither be just nor or proper, nor in the interest of justice that pending the dispute before a constitutional court, central government exercises executive power pre-deciding the issue in favor of one state. Now, even today, my petitions are pending. They have chosen to withdraw. But that doesn't confer the power on central government to pre-decide the issue in respect of my petition. In view thereof, in my opinion, since the matter is sub judice before a court of law, therefore during the pendency of dispute between Andhra Pradesh and Telangana in Telangana High Court, it would not be appropriate for the Government of India to issue proposed direction under Section 92, as indicated in the draft order, asking Telangana government to make payment to Andhra Pradesh. In view of my opinion, is also above, no separate opinion is warranted. Then, Millard, it goes back to the Ministry of Power. Now, Millard, very interesting again. Kindly come to page 24. This is a noting made on 8th July 2022. It starts at page 24 and goes on till page 29. And Millard, page 26, para 5. Post bifurcation, Telangana had been paying for power. They had been purchasing, but subsequently they are not paid. During the meeting taken also, Telangana, they don't have any dispute, etc., which is incorrect, Millard. My lords have already noted the earlier noting. Then, Millard, kindly come to the next page, Millard, where issue was discussed on 25.1, para 8. In the committee held under the chairmanship of Secretary involving Secretary Ministry of Water Resources, Additional Secretary PMO, Joint Secretaries of other ministries from Government of India. From the Andhra Pradesh side, delegation was led by their minister along with office of its state. Now, where is Telangana? No officer, no minister, nobody from Telangana. They were not even told about that meeting. The meeting is held behind the back of the state of Telangana. During the meeting, committee decided that under Section 92, government in India can issue order without any notice, without any taking my say in the matter. Then, sorry? Huh? Yes, that's right, that's right. But if I'm again bringing to my lord's notice that they are conscious of all this. Kindly now come to page 28, para 11.1. As mentioned in earlier para, based on the opinion of Ministry of Law and Justice, the opinion of Ministry of Law and Justice was informed to the parties, and since the matter is sub judice, direction may not be issued by Government of India under Section 9. As on date, the claim made by Andhra Pradesh is unsettled for non-payment of power dues to the extent of around 6,000 crore by Telangana response after bifurcation for electricity. Subsequently, Telangana, by the letter dated 5/6/22, has claimed that Telangana has to receive an amount of rupees 17,420 crore and owes an amount of around rupees 4,887 crore to Andhra Pradesh. Thus, the net amount receivable from Andhra Pradesh would be around 12,500 crore. However, it is felt that these amounts are not supported by any document and may not be taken into cognizance. I have filed that petitions. They are parties to that. No reply from any of them. No denial of the dues. And from where do you get it? The amount due to me after netting what I have paid will be 12,500 crore, but it is recorded by everybody, by one officer, everybody else merely putting a dovima. It is felt that these amounts are not supported by any documents and may not be taken into account. Did you ask me? Was Telangana asked about this? Nothing. My petitions are pending here. No reply filed by Andhra, AP, Tenco, any of them. They are aware that the petitions are pending. Further, it is informed that there was a meeting held on 19th August 2019 between Andhra Pradesh Power Utilities and Telangana Power Utilities, and in minutes were signed for the amounts agreed by the parties. As per the minutes, it has been observed that after settling the dues of both parties, there will be a net payment of 209 crore payable by Telangana to Andhra Pradesh. This is also incorrect. My lords have seen the minute assuming it is 209 crore after this, even according to that, you are asking me now to pay some 7,000, 8,000 crore. They are conscious of this fact that amounts are due and both parties have agreed. And after letting that it may be 209 crore. That is not the amount that I've been asked to pay. Andhra Pradesh in its letter dated 10th June has informed that in view of the position intimated to them as per opinion of the Ministry of Law and Justice, they decided to withdraw the petition and the withdrawal petition was admitted by Honorable High Court of Telangana. Said petition for withdrawal is supposed to be at the side, however, IA is allowed. Writ petition is dismissed as withdrawn. My writ petitions are pending. That's not taken note of. Thereafter, Telangana has preferred petition, the Honorable High Court of Telangana and filed petition, which was heard on 13th, ordering to cause notice as to why writ petition should not be admitted. Under this situation, the matter is sub judice again. Now, in a part file on the subject, Honorable Minister for Power made the following observation. A writ petition has been filed by Government of Telangana in the High Court. Writ petition has not been admitted. Notice has been issued. Therefore, the Minister says writ petition has not been admitted. So it is legally known as a very new proposition of law, I must say. I have not heard this. Writ petition, intent rain notice issued. Writ petition is known as an extraordinarily new legal proposition by the Honorable Minister. If Millard, we have to give adjudicatory powers to such persons, God save us. I'm sure the learned ASD will not defend this part of the order anyway. It's part of the notice.
Okay. Yes.
No say is granted. Even if it is sub judice. One law for Andhra, one law for Telangana. If Andhra Pradesh writ petition is pending, it is sub judice, therefore no order will be issued under Section 92. If Telangana writ petition is pending, even though it is sub judice, still an order will be issued. That is another new legal proposition.
One minute. Yes.
This only reminds us why for decades this state, people of the state had to fight for their rights. And finally, some hope came in 2014, but yet it is to come to fruition. Still, we are fighting for what is 811 TMC allocated from out of Krishna River, 512 TMC taken by state of Andhra Pradesh for outside basin. Water is required for the drought-stricken areas in Telangana. 512 out of 811 TMC water is taken. Areas in Andhra Pradesh, most of which goes to outside basin. Within basin requirement is not met. But in judicial service, what is happening? In administrative service, what is happening? My lords know, I don't want to speak about it. But these were all some of the complaints which gave rise to the grievance which ultimately led to the reorganization of the state. And look at the way the writ petition of Andhra Pradesh is pending, it is sub judice, therefore no order can be issued. Writ petition of Telangana is pending, no stay order, therefore government may ignore. What is this? This is a new law that's being propounded. No, even in Andhra's case, there was no interim order. So, whereas there is an interim order granted in my petition before the competent tribunal, the State Electricity Commission, that is not even noticed. And Andhra Pradesh says there is no order restraining you. Extraordinary. Then the government Ministry of Law may confirm that this is the legal position. Then they seek a further opinion. And that opinion, my lords will get it at 8:35. Tendency of our petition, it appears as if the learned Solicitor General has not been apprised of it. Otherwise, I personally believe the Solicitor General would not have given an opinion to go ahead. Paragraph 3. Subsequent to the previous opinion, State of Andhra Pradesh has withdrawn the petition. Therefore, a subsequent petition has been filed by Telangana Power Generation Corporation. I have seen the opinion of Honorable Power Minister. In that regard, it is clarified that merely because a petition has not been admitted, it cannot be said that the same is honest. In the said petition, notice has been issued and response has been asked to file reply. It is, however, correct in the absence of any stay order, parties may continue to act in accordance with the law subject to final outcome of the petition. It is further clarified that in view of the withdrawal of the petition filed by the State of Andhra Pradesh, there is no legal impediment for state of petition. I don't know. There was no stay order even in Andhra Pradesh petition. But the solicitor took the view, sub judice, therefore no order can be issued. But suddenly, in this, he says, he records that Telangana Genco has filed a petition. Telangana Discom has filed a petition actually. Discom, Genco, everybody. And the amounts due are much more. And says no impediment. It may, however, be noted that the same would be openly challenged by the affected party before the appropriate judicial forum. Based on which, now an order has been issued, and the taking into account the clarificatory opinion, and please come to page 46. It's page 46, I think, is the draft order. And what is finally issued is different, but I want to read the draft order. Page 46. Middle of the page, draft order. Then AP Reorganization Act is set out. Paragraph 4. Whereas Power System Corporation in its letter 18/6/2014 conveyed that during the meeting held on
Page 46.
Page 46 middle, draft order. My Lord Sahib.
Yes.
My Lord Sahib.
Paragraph 4 in view of Ministry of Law.
Also, draft order is submitted for consideration and approval, and then the draft order. Page 47. After setting out section 92, page 47, paragraph 4. Whereas POSOCO, in its letter dated 18/6/2014, conveyed that during the meeting held on 28/3/2014, Task Force Committee constituted for the purpose of finalizing the share of Telangana and AP from shared project. Scheduling procedure was deliberated and consented by all the Task Force Committee members, including AP and Telangana, based on deliberation. POSOCO advised APSLDC to continue with the existing scheduling procedure. In accordance with the decision taken, AP Genco supplied power to TL Discom. Whereas AP Genco has supplied power, post bifurcation, which is under existing PPA cycle, so this issue is related to power supply use. Whereas various representations have been received from State of Andhra Pradesh that regarding power use, for power supply to, from 2014 to 10/6, for which Telangana has not paid the dues. AP Genco had supplied the power under power purchase agreement signed with Telangana under the obligation post bifurcation state of Andhra Pradesh. Whereas principal amount of 3,441 crore has been recorded in the minutes of meeting held. This amount has also been mentioned in the letter dated 5/6/22 from Honorable Finance Minister of Telangana. Minister, it was also recorded in the minutes of meeting. Now, I'm going to read that letter of Finance Minister of Telangana where our claims are set out. That letter is taken note of. There are, what is taken note of is that I accept that this amount of 3,441 crore is due. But what is they owe us, and therefore how much money is due from AP, that is not mentioned here. Honorable funds addressed us also. It was also recorded in the minutes of meeting that there is no dispute. I complete this letter. Taken by so that there is no dispute of the principal amount. Late payment surcharge is calculated as applicable to be paid in addition. As a matter of principle, every right of one party entitled to a corresponding duty. Therefore, Government of India, in exercise of powers vested in it under Section 92, hereby orders the concerned PPA holder discoms of successor state of Telangana to pay due amount generating company. Kindly mark this, very, very important. Now the order changes it completely. This says payment will be made by discoms to Genco, because that is what is due under PPA, assuming they have the power. That is the highest that they could have done. Today, state of Telangana has been ordered to pay state of Andhra Pradesh. Where do they get it? How are they involved in regard to this? Except that the Chief Minister of Andhra Pradesh has written. This is the draft final letter. He is now asking state of Telangana shall pay the due amount to successor state of Andhra Pradesh. I will need about an hour minute.
You can continue for another 10-15 minutes.
10-15 minutes I'll continue, but I wouldn't be able to complete.
Yes.
Yes, that's right. I'll continue. No. Now, therefore, even they know exactly, the government, the section officer concerned and the officials concerned knew that PPA governs the relations between the parties. There is a commercial dispute. Genco of Andhra Pradesh has entered into a commercial arrangement in regard to supply of power to the discoms of Telangana. Discoms of Telangana have owe some money. Now, this whole thing completely now is replaced by as if there is an obligation. Why? Because under Section 92, perhaps they felt it would be difficult for any direction being issued to the discoms to make payment to Gencos. It is only in regard to direction can be issued only to the states. Therefore, no, the proposal is completely given up. Now, kindly come to the finance minister's letter, which is referred to here. Yes. Yes. Now, let kindly come to, my lords have seen the noting file, and Miller in the draft letter, Miller, the final letter doesn't even mention this. Draft letter mentions the finance minister's letter of 5th June 2022, flagged. That's what it says. Now, kindly see that letter, which is at page 148. 142. 1 minute. Yes, yes. 142 million. There are two letters on 5th June. Request for early settlement of the issue of dues payable by power utilities of Andhra Pradesh to Telangana and request for intervention in the matter of proposed adjustment of dues claimed by Andhra Pradesh for fixing the borrowing limits for Telangana for the year 2022-23. Issues of dues payable by Andhra Pradesh power utilities to Telangana have been pending for a long time. With the possibility of Union Finance Ministry adjusting the interstate dues for the purpose of fixing borrowing limits for the year 2022-23, the fiscal responsibility and budget management, there is an urgent need to solve the issue. Right from the formation of state, government of Telangana have been following an accommodative policy to settle all issues related to the power sector. Power utilities of Andhra Pradesh and Telangana were bifurcated 8 years ago. And there are a number of issues arising out of this bifurcation. Ignoring the bifurcation issues, AP Genco has been insisting on payment of dues for power supplied by Telangana in the initial years of the formation of state, which is a post-bifurcation issue. Post-bifurcation, Andhra Pradesh has not scheduled power to deficit state of Telangana as per Act and cancelled the fee. In view of this, Telangana had to purchase costly power from market and had to be compensated. In fact, following the bifurcation, power utilities in Telangana had to receive an amount of 17,240 crore from AP Power Utility. After adjusting for the power supplied by AP Genco to Telangana, net amount receivable by AP Power Utilities is 12,532 crore. Details of dues receivable from AP Power Utilities are presented in the table below. Receivable from AP Discom. Debt servicing of Anantapur and Kurnool district. These have gone to AP Discom. I have paid the money on account of what AP Genco had to discharge to the lending institution from which they have borrowed the money. Principal amount is 2,036 crore, interest at the rate of 10.5, 939 crore, 2,975 crore. I have discharged liability of AP Genco by paying to the financial institution. No dispute in regard to this money. And that money is still outstanding. I have discharged the liability. Next, Anantapur and Kurnool, and this is provided for. District of Anantapur and Kurnool, paragraph 8 of 12th schedule expressly says it has gone to them. Anantapur and Kurnool share of ICDs taken by AP CPDCL to meet power purchase cost. Again, I have paid for it, though it has gone to them. 301 crore principal amount, 221 crore interest, 522 crore. These two together, 3,497 crore. Then receivable from AP Discom towards power purchase, cost incurred by us for power purchase, because they did not supply under PPA, we had to purchase from market, and that amount comes to 6,555 crore. Then receivable from AP Transco, because these the employees trust money, etc., is all with the AP Transco and AP Genco. That amount invest. Now the employees are separated, divided. The distribution has taken place. Amount due under this head is 1,730 crore. Then receivable from AP Genco, excess liability physically discharged by TS Genco towards common loans, we have paid. TS Genco share of discount bonds retained by AP Genco, TS Genco trust share of investment receivable from AP Genco trust, their liability we have discharged, and all these put together come to 4,026 crore. Receivable from AP Power Development Corporation, these are the amounts. Now, none of these is in regard to distribution of assets. Kindly mark this. This is all in regard to my having discharged their liabilities, and they have to pay me. They have not paid. They don't want to pay. They don't want those petitions to be taken up before my lord. They are still pending. And in one they have filed the counter, in the other two they have not even filed the counter. And these amounts are due. This letter is taken note of in the draft letter to be sent to me. The final result doesn't even speak about. How did the government, what decision has the government of India taken on this? This letter is addressed by us to government of India. Letter receivable, therefore, is 12,532 crore. Basis and justification by power utilities to Telangana listed. We have given all the reasoning, all the documents would have been made available. Therefore, Miller, quickly now come to page 147. It may be indicated in this context that the AP Genco filed a petition in the Honorable High Court of Telangana regarding the issue of dues, and the counter was filed by Telangana Transco in this regard. Case is posted for hearing on 25/7/2022. Matter is now sub judice. That is what they withdraw. In the 12th meeting of Standing Committee of Southern Zonal Council held on 28/5/22 at Thiruvananthapuram, one of the agenda items relates to legal opinion on the dues payable by AP Transport Telangana in the agenda law. It is mentioned since the matter is sub judice before court of law, it may not be proper for Government of India to issue any direction. In view of the position explained above, I earnestly request you to ensure that pending dues claimed by Government of Andhra Pradesh are not adjusted against the market borrowing limit, as the Ministry of Home Affairs has a major role in dispute resolution on matters relating to bifurcation. I request that the matter may be taken up with the Ministry of Finance. Next, never in the past claims of interstate dues were taken to account while fixing borrowing. This is addressed to Ministry of Home Affairs because they are having all these meetings, and Miller, a similar letter is sent to Power. All the same thing is noted. And Miller, we also bring to the notice the standing committee meeting on 28/5 where the matter has been posted to September. In spite of all that, it is not even taken note of. This letter mentions the meeting of the Southern Zonal Council on 28/5, which has kept the matter pending and to be taken up at the next meeting. That is not even taken note of in the noting file which my lords have seen. This is the status. I will continue. I'll place the relevance.
So, when Mr.
I understand that my lords have changed the hallway from 19
yes,
to
18.
In which case, can I come on 19th and complete the articles?
Yes.
If it is
Yes, senior counsels. 19th.
19th.
Yes, yes, sure. 19th, it may not be over. Depends on how much time it takes. Then you can, depending upon, you can appeal through video conference. Yes. Market presence, both the cases. Yes, yes. Oh. We thought that he can take the benefit like and appear, whatever your this thing, you have to decide. Mr. C.S. Vaidyanathan, learned senior counsel for the that can continue. We thought that we will ask we can ask Registrar Judicial to keep this in his custody, right? Huh? Registrar Judicial will keep in the custody and produce it on the next date of. Yes. The original, this thing, right? Original note filed by Union of India shall be kept by Registrar Judicial in sealed cover and shall be produced on the next date of hearing, that is 19/9. This and will you, Mr. Vaidyanathan, give us a photocopy or any, if you can give a photocopy of these notes, because this will go into now sealed cover. They keep this in a sealed cover, Registrar Judicial will produce it. Table.